Here, my lord, hearing was concluded by the earlier bench. But my lord, the judgment could not be delivered. That's why the court released the matter and directed the matter place the next available bench.
Which bench heard the matter?
Justice Talukdar's.
With?
My lord, the determination of Justice Talukdar was there,
Sitting with?
sitting with Supratim Bhattacharya. A hearing was concluded on my part, petitioner part, and hearing was also concluded on the part of the state respondents. Only a reply was required to be given by the petition.
It's better you ask for an assignment of a bench where Justice Supratim Bhattacharya is available. Because if his lordship has heard this matter,
Yes.
otherwise for us to be a fresh hearing.
Fresh hearing, let me fresh hearing. Otherwise, I do not know whether I will get chance. I have served the notice upon the other side.
It's a hearing matter.
No. Application under the application, hearing concluded. It was
Which year? Which year?
year, my lord, 2022.
Give us, as and when these 22 matters will be listed, will be there.
Very well.
Maybe
And other, my lord, the other application, should I hand over the copy of the other applications matter?
No,
Application for stay, that I am handing over. Get.
inclusion for mandamus appeal, my lord.
No.
Composite and pair of the petitioner, the composite and appointment was rejected by the trial court.
by the trial court.
Yes, ma'am.
But with notice, I have mentioned one application.
Good.
So may I have your
Matter with notice, please hand over. You need not mention.
As the application.
All matters with notice, please hand over.
application notice?
Permitted mention one matter, my lord. My lord, I filed two application in connection with a my lord mandamus appeal.
Yes.
One section 5, another my lord restoration. Now, my lord, set to 5, my lord, applications are not traceable. Since November 2022, my lord, I am searching. I wrote a letter to the my lord.
It is to be mentioned tomorrow. To mention কালকে শুনুন যে আছে ডিপার্টমেন্টকে আমাকে written explanation যদি থেকে থাকে লাগবে না yes
Item 162 of the today's list, my lord, this matter is still urgent.
what is the urgency
Urgently, that's just my lord, this selection for the post of the assistant headmaster is pending. But the honorable single judge passed an order to initiate a fresh selection. On the strength of that order, one day panel has been declared, and that is going to be put back to tomorrow.
doesn't matter if you are we're not going to stop any panel being published. Just it will be
I need to mention lordship without certified copy to file the mandamus appeal, lordship.
certified copy when the order was passed.
Lordship, the order was passed on the month. It is a pending matter, lordship, in the month of June. And we have applied for the certified copy. It is pending. We are appearing for the Howrah District Primary Council, lordship.
No, but June you applied for certified.
Lordship, we have applied for the certificate, but
When?
it was applied on 12 June, lordship.
12 June.
Lordship, it is a pending matter. The file is not coming down, lordship. That's why without only the certified copy, lordship.
Subject to
Much obliged, lordship.
Yes. Any other mentioning?
No, you kindly excuse me, kindly hear me please. When if the panel is approved, third party live will be created.
May we leave a matter justice and Lord, may I mention a matter to Justice Kumar? Lord,
Well,
matter,
Lord, you will sit singly, then you mention.
Lord, that is urgent matter because
Very
of
well,
the,
Lord,
it has
will
been
sit singly.
assigned after two honorable judges has released the matter.
It will come to his lordship. You don't
Lord,
worry.
Your lordship, may I just mention on what this matter is initially before you lordship.
Whenever he sits singly,
Lord,
it will come.
Lord, that is the reason.
This matter was initially before you lordship's bench division. Matter is part one.
All of you.
Lordship, may I just mention this matter, my lord?
Yes.
This matter was initially before this bench matter. After determination change, matter was part heard in this bench. The matter was later assigned to the division bench of Justice Arijit Banerjee. The Justice Arijit Banerjee released the matter on the ground that since the matter is pending part heard before this bench. If you lordship kindly Release the matter from part heard.
আমাদের পাঠার আছে। ঠিক আছে, তুমি মেনশন করে দিও।
Lordship,
Lordship, may I be-
Yes, just wait. On 30th, you upon notice to mention if this matter is not such.
complainant is a lawyer of Alipur court. Lord, the matter.
Contempt is pen. Contempt is pen.
Very well, we will call with.
The complainant
may
is
be
lawyer of Alipur court, Lord, are unable to get access to
His
justice. Lord.
lordship will sit singly.
Two of the honorable judges has
No,
released the
lordship
matter
will sit singly, you'll just.
for
watch
taking up
list.
the matter. That is the reason that I was
Very
seeking.
well, if it is there, whenever his lordship sits singly, it will be listed before his.
Lordship, may I be permitted to mention this contempt application of 2023, ma'am? Contempt application. It was
Lordship, may I be permitted to mention?
Will be expired.
Yes, yes.
Lordship,
Lordship kindly.
Please, she is mentioning, yes.
Lordship, may I be permitted to mention, Lordship, one matter for extension of interim order, your Lordship. On the last occasion,
It is appearing in the list.
no, Lordship, the matter was supposed to appear on the combined monthly list of July. The last date of interim order is on 31st July, your Lordship.
It's not appearing.
Kindly put it for extension. Will be till 31st of July, Lordship. List running now.
2022 ম্যাডাম কবে নিচ্ছি আমরা? Immediately after the forward matters.
Lord, may I be
Grateful,
permitted
Lordship.
to mention, I am mentioning this matter for inclusion under the heading to be mentioned.
Why?
There was a direction upon the respondent authority to file a report by my Lord Justice Subroto Talukdar, but since they have not file any report
No,
before
when this matter is due to appear in the list, supposed to appear in the list when?
in the month of July, this month, 3rd July, my Lord.
It's not appearing.
No.
Which year?
This year.
দেখো
20.
যবে আমাদের 2023 list
So, my Lord, this is a order passed by his.
doesn't matter, you please hand over the list. Why you are not mentioning the matter upon notice? Take it back, take it back. Don't mention the matter without notice.
Notice.
Where's the last order? Where's the last order passed?
Last, I will bring.
Give the last order to my officer. If it is due to appear, not appearing, it will appear in the list.
Yeah.
They can have a.
Deeply obliged.
With a lawsuit mentioning application for a stay, this is of 2018 and 17 and 2022. And I have served
Mentioning upon
notice.
notice.
I have served notice.
Very well.
May I
যে বছর আছে সেটা বছরে ঢুকে যাবে।
I have great.
Just do it.
May I have Lordship's kind leave to file an mandamus appeal, Lordship, with the server copy, Lordship. I cannot,
When the order was passed.
Lordship, the order was passed on 17th February 2023.
Sorry, no.
Lordship kindly.
17th February, you have filing in month of July. You come with a certified copy. Will not.
May I be permitted to mention one of this restoration application?
My Lord.
Separate appeals for inclusion in the list. Separate appeals for inclusion in the list.
You mentioning about notice.
Yes, yes, notice have been given, notice has been given. Deeply obliged.
May I be pleased to mention a
Notice
matter
the
for,
Please take the microphone.
may I be
grateful,
pleased to mention a matter for inclusion in the list. So this is an appeal which had been,
No, Are you mentioning about notice?
yes. So just a second, I want to indicate that it was an matter which had been heard by my lord and along with Justice Sogata Bhattacharya. And that matter, order,
Ordered.
no, the order had been passed and vacating applications had been filed, but that vacating application has never been heard by
Which matter?
this is, my lord, this is in relation to Satyanarayan AC Market. So
Orders had been passed in December 12, 2019 and January 2020, wherein the respondents herein had been directed to make payment of license fee, maintenance charges, air condition charges and electricity charges.
It is a FMA. You go before the regular bench, mention it. You go before the regular bench, have the FMA heard. Matter to end. As and when we sit, we shall sit with it, but nothing to do with this. You are having a division bench hearing the main FMA. Why don't you have the matter listed before the division bench and have this matter disposed of on merits?
The order had
If
been
they are
passed
not
by
paying-
you, so vacating application had been
Your
preferred.
main appeal has to be heard by a bench. That bench is there. As and when we sit, we shall sit with it, but that cannot prevent you from having the appeal heard.
Okay.
যখন বসবো দিয়ে দেবে না রেখে দাও আমার সৌগত heard. Yes, call the list.
Order matter item number 1. Matter time to time appeared, your lordship was pleased to hear the matter. On earlier occasion before election, it was fixed. Before election, your lordship was pleased to fix the matter where Advocate General would run it, Advocate General would appear in the matter. It is fixed today. Well, two matters are there, analogous matters. The first appeal. Contractor has what?
Setting aside.
There was recommendation more for making payment.
Who is for the state?
Mr. Orindo Mondol, Mr. Sinha appeared, and the last occasion, a learned Advocate General appeared.
Take it down.
Fourth August. Milord, twice there, thrice, Milord, it was taken time by the, at
No,
least
you
4 times.
Just because you are not the regular bench, if it is settled well, otherwise we'll go back to the regular bench. So we are waiting for because the Advocate General is not here. So just give a notice to Mr. Sinha, 4th August it will appear. Yes.
I
call the
shall
list.
sub notice of the
Mr. Puridot Sinha, you serve a notice. Yes. Call the list.
application item number 3.
My lord, I'm appearing for the appellant. My lord, we are led by Mr. Shoptangshu Vasu. He's on his legs before courtroom number 5, my lord. I'm
Pass it
seeking
over, pass it
pass
over, yes, pass it over once. Yes.
Grateful, my lord.
Yes. First call টা পড়ে যাও। First call পড়ে যাও, পরপরটা পড়ো। First call, সুমিত আসেনি আজকে আবার। Just wait, let it be a first call. Yes, call the list.
Item number 3.
Little long passover, madam, on my matter.
No, just wait. Yes, once we have passed it over, it's passover. Yes.
Yes, long passover.
Oh, yes, oh.
Item number
For
4.
non-passover will come back. Make some arrangement. Yes,
No,
sorry.
no.
Call the
Overnight
list.
party is going on.
No, maybe. We don't know. Yes, call the list.
Item number 5.
Pass it over.
Item 6.
6, I appear for the appellants.
Yes.
I'm appearing for the appellant.
Very well. Just first call. Yes.
7. 8. 9.
10,
10, Manal, I am appearing on behalf of state.
For the list.
11,
Take a
11,
11, I am for the respondent.
12, 13, 14,
Regarding this matter, I'm praying for not today, madam.
Why not today?
Learned Senior Mr. Bolailal shows not come to court today. He is in this matter. So I'm praying for not today, madam.
14 data record for and adjourn the straight for on behalf. Time, if you are not there, we'll dismiss it. Already this is matter being called at least thrice over a period of time. We'll not adjourn this. We'll just adjourn it for 1 week.
15, 16,
No further adjournment.
16, I am appearing on behalf of state
No further
respondent.
adjournment should be granted on the agenda. No further adjournment shall be granted on the agenda. Yes, 15. Yes, call 16.
16,
16, I am appearing on behalf of state.
17, 17 to 20.
Very well, call the list.
3.
Yes,
Item number 3.
give the papers.
Problem is when the overnight part is there, there's a creates problem. But state is not here. This is
My lord, I am for the state, my lord. I have a predicament in this matter. As a learned junior who is there, he has been depaneled. So the
He may not be there. You are there.
instructions are with him. My lord, so
I'm not going to adjourn this second call. Yes, give the.
lordship, kindly,
You are the senior, you will argue.
no, I'll have to seek for instruction from the department, lordship, afresh.
Pausari, come.
He. তপনদা আছে
last time Mr. Tapan.
Lordship was subsequently pleased to engage Mr. Tapan Mukherjee in this matter. আরে আমার কাছে নেই তো কিছু কি করবো এখন আছে এখন
That, my lord, the hearing the special bench matter, that is not covered.
Now, this can one was reaffirmed and filed.
Yes, reaffirmed.
What is the report of the department regarding tracing out?
কি তোমরা রেডি আছো
What is the department report of trace out the original?
Reaffirm করতে হবে। পাওয়া যাচ্ছিল না। Mr. Mukherjee's view was that my lord is hearing in a matter the payment in the higher scale. That is not covered by this. This is a case where my lord pre-notification and pre-expenditure act come into force. I got the benefit of higher. I entitled to get the benefit of higher scale because of enhancement of my qualification on the relevant subject.
Where is Mr. Mukherjee?
Mr. Mukherjee is code number 5, your lordship.
Probably my lord has settled this issue. And obtain leave granted, only communication has not reached to me. I obtained the enhanced qualification of MA on the relevant subject. And there is an application order for 1027. And I will be candid manner before the lower court manner, all documents were not there. I filed an application, your lordship was pleased to allow this.
পেন্ডিং আছে তো হাইট স্কেল এখানে পেন্ডিং আছে রাজার বেঞ্চ
Now, have you disclosed the permission of the district inspector of schools?
Only that is not there. Accepting that everything is there. My leave was granted by the board.
But the district inspector of schools have not granted you
এখানে করার জন্য
prior permission.
তারপরে পেন্ডিং
Right, kindly see what the documents are.
সেম করে
Kindly take
Tell
my,
us
তারপরে এখানে
that whether the
পেন্ডিং আছে
district inspector of schools, Nodia,
Right,
gave
yes.
you the permission to appear in the said examination or not.
ফাইন্ড করে দিয়েছিল হাইট
if there is no express,
There is no, let us proceed, there is no, very well.
then my lord, I obtain, my lord, kindly take my order 4127 application. Kindly come to page 25 of my application.
Have you disclosed any paper showing that the school authority had sent any paper to the
Yes, yes, yes.
that you have disclosed now?
Disclosed, but kindly come to 25. My leave granted by the board,
Whether pursuant to this order, bench constituted of
page 25 of my order 4127.
হাইট স্কেল পেন্ডিং আছে আমি জানি একটা কিন্তু এটা আমি এই মুহূর্তে আমার কাছে নেই পেন্ডিং আছে
In 2005,
constitute হয়েছিল।
এটা পেন্ডিং আছে আমার মনে হচ্ছে 343 কিন্তু 343 কত অরিজিনাল সাইডে নাম্বারটা মনে নেই হাইট স্কেল পেন্ডিং আছে আমি জানি
My lord, with the kind permission of my learned senior my lord, may I just my lord give an update my lord on this issue my lord. The issue went up to Hon'ble Supreme Court my lord.
this is not the issue.
No.
Here already there is a, yes, Mr. Mukherjee,
This is prior to that.
Mr. Mukherjee, you see, his writ petition was dismissed on the ground that district inspector of school did not accord permission. And there is nothing on record to show that the authority had sent any paper to the concerned additional district inspector of schools relating to the permission. Now he has filed an application for additional evidence that you have fairly submitted, that you have no objection. In this document, if you see the application for additional evidence,
এর মধ্যে আছে এর মধ্যে যা আছে
Order 4127 দেখো।
who is appearing for the school?
Paragraph 19 থেকে দেখো। Page 19 থেকে দেখো। School পাঠিয়েছে। Then
Now only to be decided by your lordships whether you will get the higher pay scale of pay for acquiring the postgraduate degree.
Yes, yes.
Yes, that is the only question to be decided by your lordship.
this is the
But
question.
in the meantime, West Bengal Control of Service, Control of Expenditure Act 2005 came into force and section 20 has been given overriding effect. That has been interpreted by Justice Nirjot sitting with Justice John Vishal. Then Mala Justice Topension did not agree with the view taken by the division bench. Matter was referred to the larger bench, but in the meantime, a larger number of cases was filed and they were dismissed, against which one of the SLP was filed by the respective party. Then the Supreme Court remanded the matter to the High Court and your lordship sitting in a special,
The three judge bench.
a three-judge bench.
About 1 minute. This expenditure act came into force on 27 December 2005.
Right.
But this, my client's case, he passed the examination prior to that.
No, I'm not saying that, but
So I am
section,
not covered by that.
section 20 has been given overriding effect.
For
That
example,
all-
circulars, right?
No. This act will only can have a prospective effect.
No, I'm not saying that. But section 20 has been given overriding effect.
What overriding effect?
That section or that act can only have a prospective effect.
Yes,
Now, if his case were to be considered before the act came into operation, then his case has to be considered on the basis of that.
Yes.
So I think we delivered a judgment, I myself sitting with just over the Bhattacharya.
yes, Shogota Bhattacharya.
Yes.
Staff pattern has to be considered. And what is the sanction?
He is there, expert in this field, Abdul Jamal. That is the number.
My lord sitting in upstairs, sitting with Justice Shogota Bhattacharya, with regard to the staff pattern.
No, we have,
This substitution of your lordship's khata.
Let us wait for the judgment of the special bench, whether that would be better. Because hearing has more or less concluded.
Why should I wait? If it is not covered,
Which one was concluded? Which judge? Which one? Special bench?
The special bench.
whether
No, no.
after coming into force, what will be the effect?
Only
No,
we
no,
have
there are
heard-
three issues are there.
We have only heard the Advocate General.
Yes. Control bench শুনিয়ে তোমাকে দিয়েছিলাম কোথায় গেল?
We have the order. We have passed. I don't find it here.
I will take help of Mr.
Covers this. First issue is not relating to
Supreme Court
expenditure.
strategy and hand over to my.
But first issue is not Control of Expenditure Act. Before the
Acquisition of
special.
higher qualification or qualification during the service career.
Kindly see the first issue, kindly the question of law formulated by the court,
Supreme Court.
by the Supreme Court. Whether in view of the fact acquisition of higher qualification or qualifications during the service career of an individual is the highest and the
Nah,
same
is this
act
right?
is a right and the same act as the incentive to the career advancements as well as acquiring higher status of academic brilliance. Can such a person be forced stage to lower status primarily and forced to continue to work as a lower scale of pay, which is not commensurate to have to qualifications acquired subsequent to this appointment?
The first question.
This is the first issue.
No. The thing is this. He has acquired higher qualification
Prior to
prior
coming in.
to coming into operation of this expenditure act. So his application was required to be considered at that relevant point of time. DI was supposed to either accept or reject.
Yes.
So he will decide that matter because it's only everything was sent to him.
Yes.
And I think we said in that judgment that while deciding it, the DI will consider certain things into consideration. So let him consider that and decide the matter on prior permission. That's all, because after all, a person, if he's required for any acquisition of higher qualification by a teacher, would inure to the benefit of the student unless the DI comes to a finding that there is already a teacher with such higher qualification, so it may not inure to the benefit of the student.
Yes. My lord,
That's-
kindly adjourn it. Let me have that judgment of mine. Mr. Supriya Chattopadhyay was here. I will take his assistance.
No, what is the judgment? Which one?
That judgment is post 2005 Act.
No, that is no post 2005. It is your Meghnad Rai.
No, this is the judgment Mr. Mukherjee is talking about. This is post 2005 Act.
No, but he has been selected by the West Bengal School Service Commission Act. Kindly see.
Can you give us a reference?
Report full up, yes, my lord.
আমাকে দিবি।
At 2 p.m. my lord.
আবার টুপি আমাকে দিয়ে আমি দেখবো কালকে রাত।
আমার ক্লাসে পড়াচ্ছি।
Please give it to my officer.
Kindly take
So
it up
we can
tomorrow.
take it up from the
Take it up tomorrow so that I can also go through it, assist my.
part next Monday. And please give it to my officer.
Yes, yes. The number will suffice because my lord has the computer.
পরেরটা কত?
Just give the number. Mr.
Yes, that will.
আমি এখনই দিচ্ছি।
এটা রাখুন।
And also, Mr. Mukherjee, consider the judgment also
Yes.
ours. They are
আছে আমার কাছে আছে আমার কাছে আছে
They are possibly what we said is this, that staff pattern and other things to be.
Staff
explained.
pattern.
Yes.
Staff pattern is another matter. In a particular Abdul Jaman case, my lord, your lordship observation was no prior permission in this.
Your lordship negated everything.
Yes.
Why prior permission, why all these are all irrelevant.
ওটা ওখানে লাগবে।
That we have.
Staff pattern is separate matter.
Please give his.
This will I will produce it.
আছে ওটা আছে আমি দেখি আছে আমাদের
কতদিনের ডিলে এটা?
What is the name? Abdul Jaman.
Jaman, well, I am giving within 5 minutes.
Yes, next matter, please. Yes.
সেকশন টাইপ এটা।
Item number 4.
I beg to appear for the appellant, my lord. Higher scale was granted by the DI, but from subsequent date. I am praying for from the date of appointment, notional benefit only.
Well, initially, I approached before this court, and this court directed the DI, mandatory direction was given to give higher scale of pay. But from when I am entitled, that was not directed.
Page 43 pin also. When the learned trial judge rejected the depiction of the constructive res judicata, because on earlier writ petition, he has not prayed for. We have prayed for, but was not allowed by the court. Page 43 for a moment.
No, but it may not be constructive res judicata, with due respect, because he asked for it, he did not get.
No, madam, that was earlier writ petitions, but the
Earlier this petition, he asked for it and he did not get.
wait, that means prior refusal,
No,
team
no.
refusal.
In disposing of that matter, what was the observation made?
The condition.
Only see on page 29.
In my view,
The petition entered to
Yes.
get high scale for his honors degree.
yes, there are circulars in favor of granting high scale of pay.
Hmm.
Fine?
Yes.
In my view, the writ petitioner is entitled to get higher scale of pay for his honors degree.
Yes.
Correct?
Yes.
But date is not fixed from where.
Yeah.
Accordingly, direct the district school to release the higher scale of pay in favor of the writ petitioner within 8 weeks.
But he could have filed application for clarifications or a review of this order.
You see, the learned judge said in this, he said that he is entitled to higher scale of pay.
High scale of pay.
And,
He has been given.
and the direct inspector of school has directed him to pay higher scale of pay.
Yeah.
So he has not decided, the learned single judge has not decided the period. It left it to the
DI.
No. But learned trial judge held that he is entitled to high pay scale.
So in terms of the circular,
Yeah.
he said there are circulars in favor of granting higher scale of pay. Fine. Come to page 29,
Yes, ma'am.
fourth paragraph,
Yes.
last sentence. There are circulars in favor of granting higher scale of pay. In my view, the writ petitioner is entitled to get higher scale of pay for his honors degree.
But which circular applicable, which not circular applicable.
Suppose he had not said so.
Yeah.
So accordingly, I direct the district inspector school to release the higher scale of pay.
Pay, yes.
Correct?
Yes.
Now,
Next page is the order of the DI.
next page is the order of the DI,
Page
Page
31. Page 31.
31.
In compliance of the order dated 26 September 2012 passed by Justice Ashok Das Adhikari in above petition.
He
On of
has
the
been
scale
taking
of fees
KBC
hereby
school.
sanctioned favors
The
in
higher scale of
Adhikari.
pay is sanctioned from with effect from 17 July 2006. This he has challenged.
Yes.
But where is the res judicata?
Mullah,
Where is the res judicata?
Mullah, because in the earlier petition, my Lord Justice Adhikari has not said that he will get there from which date.
No, that has not been decided, left open.
No, Mullah.
Yes.
Mullah, if the issue was there, whether he one and which from which date. Two issues were there.
Question is this here. What was the prayer made in the earlier writ petition?
That I have.
What was the prayer made?
Earlier petition prayer, that's it. And not in the annex in the petition. That has been dealt with by Justice. Want to kindly see? Want to kindly see page 40 for a moment? A read in the nature of mandamus directing the commanding respondents, more particular day of schools,
to give approval and a function in getting higher pay scale for since the date of taking classes higher secondary school. High schools authority having requisite qualification in favor of the petitioner in terms of the government software and thereby make the rule absolute. That means from 1995, we want
99 or 99.
99. That was not granted by the learned single judge earlier.
No, learned single judge, it was not, he said that not granted. Learned single judge said that the learned council of the state submits that at the time of getting appointment of petitioner declared himself as graduate. Therefore, he is not entitled to get higher scale of pay. Fine.
Yes.
Had the learned council appearing for the parties and consider submission made by the learned council, there are circulars in favor of granting higher scale of pay. Fine.
Yes.
In my view, the petitioner is entitled to get higher scale of pay for his honesty.
But what was paid?
No, he may not. See, that's why this writ petition was allowed by directing that he is entitled to higher scale of pay.
Higher pay scale.
And the learned single judge did not specify the date.
That means either order has to be reviewed or other order has to be challenged.
No, that's why, no. Now that DI has decided from 2006 he will get.
Yes.
That cannot be a res judicata so far as this order is
In
concerned.
my proposal, because on the earlier writ petition, when it was disposed of by the Soumen court,
He granted higher scale of pay.
high pay scale.
There are circulars in favor of granting higher scale of pay. So you are directed, I direct the district inspector school to release the higher scale of pay in
Right.
favor of the writ petitioner.
And can you see circular of 27th of January 1995. 27th January 1995 was mentioned there. That means that
The learned single judge may not have said that he will, because you see, these circulars, when this reference is made, certainly is made reference to the circulars referred to in the earlier writ petition.
yes.
So how it can be a constituted res
But can
judicata?
you see if there is a pair for that
Constituted res judicata will arise provided you have the means, you have the opportunity to raise that issue, but you have not raised it.
he has raised the issue.
He raised the issue.
Yes.
He raised the issue and the court did not say that he will not get it from 95. The court says on the contrary, there are circulars in favor of granting high scale of pay. So if there are circulars, means the circulars that he has relied upon.
No, but which circular applicable to him, that has not been
That is
mentioned.
not been decided.
That
but
has
that-
not been decided.
But that is left open. So it cannot be a
No,
constituted res judicata.
left upon. That means,
Not decided.
his entitlement of high pay scale has been accepted by the court.
But now he is questioning that your decision of fixing a date was not proper in terms of the circulars. Because here, the learned single judge has said there are circulars in favor of granting scale of pay. Fine. Now, and accordingly, you are directed to release his higher scale of pay. In terms of that, when it was decided by the DI school, he said that the higher scale of pay is sanctioned, the date of this application, he has also not given a reason why it should be from 17th July. He has not given a reason. He ought to have given a reason. Did he give any reason? He has not given any reason for this. So this order has to go.
If pilot wants reason, certainly will give reason.
This reason is not there.
Can you see page 31?
Yes. In
compliance
compliance
of the
with the
order,
order,
Mr.
in
Satar,
compliance with the order, the Honorable Justice Satar
He has
is
fiscal
hereby
sanction
sanctioned
the date
in
of
favor
the
of this,
application of the high pay
as he
scale
has been
to
taking
the-
chemistry
Can you see
classes.
that? He has given the language. That the date
He has been
of his
taking,
application. The date of his application for higher scale of pay to the school authority. Last line. Have you Lord Justice got it? He has given the reasons.
no, but if the circular says otherwise,
No. He applied on 17th of July 2006.
no, he applied very well. If he is otherwise entitled in law to get it, if he is otherwise entitled to in law and get it, he acquired the degree in 1999.
But when applied, but government is not supposed to know when he is got. He must inform the government that on that I want the higher pay scale. On 17th of July 2006, government was informed, then government has granted him in terms of the court's order. Now in a subsequent petition, no, this is, the date is incorrect.
No, let him consider that whether his application for higher scale of play from retrospective effect on the basis of this circulars can be considered or not. That's all.
But now, on the date of the application is a very important matter.
And I am not,
Date of the application is important, no doubt. But after all, if he has acquired a higher degree, it is beneficial if it is otherwise permissible, because
Staff change,
yes,
sanction.
exactly, that has to be considered by him, because after all, he's a professor, he's a teacher.
Teacher.
So we must all respect the teachers for what they're
Yes,
doing.
certainly, madam. We have all respect to the teachers.
So if you have
Because we
respect-
are also students.
Yes, yes. So that is why you will consider it, that's all. We are not taking out.
Your lordship, kindly excuse me.
Yes, yes.
My junior will be there.
No, please hear, please listen to us. The appeal is arising out of the order dated Guidelines apart from staff pattern,
Staff pattern and the staff strength.
staff pattern and staff strength.
DI.
No, if the order of the DI goes, then you don't get anything.
Yes, yes. Good evening. Another indulgence, I am praying, my lord. Same DI has granted higher scale of pay similarly circumstanced person from 1999, page 32. While he will consider, my lord, he will also consider page 32 of the application.
Of hearing, you produce all
একটা
the
কাজ
documents.
করবে এখানে কনসিডারেশন আগে বলবে দ্য ল্যান্ড কাউন্সিল লাস্ট ইয়ার সেটা সাইড বলো না তারা
That
ওই তো আগে
Well, your lordship, division में क्या? Paragraph 13 में your lordship decided.
আচ্ছা, হবে।
is that also considered Meghnath? Right.
Yes, yes. Both the order your lordship passed the both the judgment.
Thank you.
Last question, Lordship, please to direct me to serve the before the GP, my lord, I have served.
Ms. Samant is here. Why you are hiding? It must be visible. Yes, are you engaged in this matter?
GP office কি কপি স্যার
GP office দিয়েছে। সে তোমার করে দিয়েছে একে। অসীমকে তোমার করে দিয়েছে। অসীম আলমারি। Last question, my lord, I have submitted to notification, that is the relevant notification for consideration of our issue, my lord. Selection process of
You
2000,
take
my
an
lord.
instruction this matter. The order is very clear, the last order. Take down.
my lord, he is serving only the notice to the learned government pleader's office, my lord. Earlier occasion.
No, but will you accept it, madam?
My lord,
You of the state.
yes, my lord, kindly give a copy, my lord.
The state is not represented. Now, in spite, have you served?
Lordship.
In spite of service, in spite of
Today, my
can
lord.
you serve it?
Today, my
Tomorrow,
lord. Today, my lord. Bye.
by tomorrow, by tomorrow. Remembrance will regularize your appointment,
Government pleader, learned government pleader.
not the legal remembrance.
No, learned government.
Government leader should regular. Doubt why it should not be applicable. That's all.
I will see and I will take a appropriate instruction from the DI.
Please.
Grateful, my lord.
It's better, please tell the government leader
Yes.
that in education matters, someone from the education department should be present in court.
But Mr. Chattopadhyay is here.
No. Officers of the,
Education department.
Yes.
Yes, he is here. Someone is here.
someone is here, where is he? Oh, acha. Oh, very
The
good,
education department.
very good. So she must be following, watching the court, so
She is watching the list and
she
taking
must-
note.
She must assist the court,
My lord, I will.
yes.
I'm nuclear.
ও, আপনি বুঝতে পারবেন আমি কেটে কেটে
Please state respondent.
please give us a time.
My lord, there is two applications. One is for section 5 of filing of
Yes.
the appeal.
Yes,
My lord, there is a delay of 542 days in filing the appeal, my lord. My lord, we have taken out an application. My lord, the only ground that we have pleaded, my lord, that is the communication gap between the learned lawyer and the petitioner. My lord, kindly takes up. This application disposed of. এই দেখো এই order. তোমরা appeal করেছো।
You are not in the zone of consideration.
My lord, we have taken two grounds in the appeal, my lord. No, my lord, may I say this, my lord? My lord, this calculation was not made as per the rules. But the rules of 2001 suggest otherwise. May I show you, lordships? My first point is this calculation. My lord, we were not allowed to revert back to this, my lord, report that was filed before the lower single judge. But the calculation that was made pursuant to 2001 rules.
First of all, when you have been given the roll number, you should have ascertained this after you become unsuccessful to file the
No, my
written.
lord, from the initial day, I have annexed the admit card also. From the initial day of my issuance of admit card, there was series of differences with regard to my address, my particulars. Even I had to appear before the counseling with a, my lord.
Mr. Chattopadhyay, this,
Grievance against the primary council, district primary council.
Yes, my lord. But the one we have also, we have served.
no, you see that, same name, two persons.
Yes,
Appears to be so, we don't know.
yes, madam.
So who appeared for the council?
Mr. Bhaskar Prasad Baisho.
Where is he?
No, no. Here,
Pallab Chatterjee.
one Pallab Chatterjee.
So he's still in the panel.
No, primary, DPSC panel is separate, my lord.
My lord, we have served notice. My lord, may I ascertain and serve the learned council?
Pallab Chatterjee. After ছিল ভাস্কর phone number one.
No, but once you get to know of this, it is of 2009.
My lord, selection process 2009, initiated 2012, my lord, thereafter.
Sorry?
My lord, selection process initiated in 2009, my lord, thereafter examinations were held, my lord.
But when did you first time found this mistake?
My lord, we found this,
Because you were unsuccessful, your list did not appear. See,
my
there are two
lord,
things.
my name appeared as a withheld list.
Yes.
I say, my lord, that roll number that the person carries, that is the appellants in the, before your lordship, in the withheld list is the appellant, but the roll number is different. The person who is named as Indrajit Ghosh have not been appointed. I have taken the ground in that appeal, my lord. Have not been given appointment. There is no Indrajit Ghosh.
You participated on the basis of a roll number, one particular roll number.
Yes, my lord, I stick to that. I stand by that, my
And
lord.
that, and the result of the person who was withheld was
Separate roll number,
roll number.
separate roll number.
No, but respondent number 4 has filed a report.
But my lord, they have not, my lord, mentioned in the report. May I take your lordship to the report, page 52 onwards of the stay application?
Section 5 allowed.
Page 52.
My lord, page 52 onwards of the stay application. They say that the roll number is wrong. They do not say anything about the person being appointed thereby. It was only that person who was left
No, but
for
your roll
appointment,
number was 1132777.
my lord.
Yes, the marks obtained by the last successful candidate is 30.6.
But this calculation, I say, my lord, I can show, demonstrate from the rules, my lord.
The marks obtained by the petitioner.
But there was no person of Indrajit Ghosh who was appointed out of the withheld list. Only that particular post was, but the person was not appointed.
Now, what was the cutoff marks?
My lord, as per their report, they have not filed any record to, my lord, substantiate this report. But as per their,
You are not a withheld candidate.
no, my lord.
You are not a withheld candidate. You did not qualify.
No, my lord, as per their report, but we could not have challenged this report because we have not my lord, accorded the opportunity to do so before the lower trial court. But why we say, my lord, from the rules?
No, but the record will speak for itself.
Yes, my lord, kindly.
Produce the record.
Yes, my lord, absolutely.
Successful candidate will obtain
Absolutely.
38.63.
My lord, the rules says otherwise.
Obtain
The rules.
Yes. Yes,
Let,
the
let
rule-
my learned senior
Yes,
friend.
the rule.
Well, the rules that was governed in that particular time, 2001 recruitment rules, well, it suggested a different sort of calculations, which was not which is not apparent on this record, my lord. These are the only two grounds that we have taken. Well, if your lordship is
No, you say that the marking was not in terms of,
absolutely,
no, what is the wrong with the marking? Tell
My
us,
lord,
you have to
my
primarily
lord.
satisfy us.
my lord, my
What is
lord,
the wrong with the marking?
my lord, my lord, if you the marking that has been done by the council,
They have given you marks.
my lord,
They have said in the report, they're categorical,
yes,
that what marks you got.
my lord,
You got 18 point, written test 18, academics 8.01, interview 2.50.
my lord.
That's all.
My lord, the schedule of calculation that they ought to have been made is as per 2001 rules. But it suggests a separate set of schedule to be calculated, which was not followed. My lord, if your lordships kindly takes up my marks sheet of the Madhyamik and tallied it with the my lord, rules prescribed therein for calculation of marks, it would not come to this, my lord. That is the initial point that I take.
Yes, sir.
That-
In spite of notice, district
Is recruitment rules 2001 rules, my lord,
consistent and since it is
rule 14.
consistent and in where you have said so in
My
your
lord,
petition. Show us a paragraph
my lord.
in the writ petition. Which paragraph you have said so?
My lord, take just
If you have not said so, will not allow you.
my lord, just one second, one second. My lord.
Not a single line. You have not challenged the marking.
Nothing has been stated.
Your case was completely different than what was you argued. The last argument. Not in conformity now, Projan. Just file produce code, that's all. You have not taken that point. Matters and urgent for a
My lord, my lord, I have taken my lord, subject to sanction
Show
of
us
your lord.
which rule is violated during marking. Show us one
My
single
lord,
paragraph,
my lord, in
one single paragraph and one single statement in your writ petition. We have not said, we have gone through it, we have not said so anywhere. You say correct the mistake, that's all. It's not there. That point is not available to you.
My lord, paragraph 38, page 15 of the stay application.
Paragraph?
38.
No, in your original writ petition, the case is made out in the appeal. This was not your case before the learned single judge.
My lord.
Then this is not your case.
My lord, it was not case because this report, my lord, came up for the first time in the writ petition. And it was not, it could not have been reverted.
You have not been.
Yeah, we were not.
You said mistaken identity. That was your case.
That was the case. Take made out in the writ
You
petition.
you knew your marks.
No, my lord, I did not know, my lord, the writ appellant was not aware of the marks. It was for the first time in the report filed. No. It was for the first time in the
Where you have said, where you have said.
page 38, paragraph 38. My lord, page 15 of the stay application.
Paragraph 38.
But I have said that it was not assessed.
Paragraph 38. You don't find.
My lord, page 4, paragraph, ground number 4.
No, it's vague.
My lord, this
Absolutely vague.
well,
You have not said that which rule was violated.
well, the extant rule means the rules that was prevailing then, my lord. 2001 rules, my lord, if I may be allowed to say so, my lord. It was only the 2001 rules that prevailed in that point of time, my lord. And it was only for the first time that the petition appellants came to know before the learned single judge.
Challenge it. Paragraph 38 does not say so.
Well, in the writ petition, I could not have.
No,
my
even paragraph 38 of the state petition. Read it for yourself what you have said. Correctness and applicability of the report filed by the with regard to the was assessed.
lord.
How the correctness is as the original record is produced with the marks. You have never said that the marks given was arbitrarily given to you.
Lord,
or
I
not
have,
in
I have,
accordance.
I have, my lord, specifically taken grounds in the memorandum of appeal, my lord. Page 4, my lord, ground number 4 in the memorandum, my lord.
The page 4 not. I've ordered this. This will be on status. क्या खुशी को
Memo appeal the web
My lord, I should have been more precise in this, my lord. I tender my apology for this, my lord.
You have no pleading.
My lord, I have taken out the grounds in the memorandum, my lord. But page 4, ground 4.
No, you have not said which rule, how it has been wrongly done.
My lord, this,
Particulars has to be given. You cannot make a vague allegation.
my lord, I
It's a
can,
vague,
my lord, I can,
completely a vague allegation.
my lord, I can demonstrate from the rules itself, my lord, before.
You have to plead that these rule is violated. Which is bad in law as the calculation of the marks has been wrongly done. Why? Which, how, what is the basic? It is onus on you to show that it has been wrongly done, not on them.
My lord, may I,
Them. And you have not said a single thing in your petition. Sorry, we'll dismiss it.
my lord, may I, madam,
Sorry, no. We cannot go on like this. You will not challenge it. You will not say anything about it. কি বলেছি বলো? Next.
grateful, my lord. I apologize, my lord, for this.
Item number 7. 7 lordships, I am appearing on behalf of state. We have not found your lordship. Item number 7, your lordships. State appellant.
Why you are not present? We said that we are not going to attend this matter.
No, Lordship
We
kindly.
have given you enough indulgence to the state.
Yes,
No further
lordship kindly. I have not found brief, your lordships. Kindly.
What?
Brief not found, your lordships.
If not found.
Yes,
You are the appellant and you could not find out the brief.
Because lordships. My illness is very difficult. Your lordships kindly adjourn 1 week, your lordships kindly. Next week, your lordships.
2016 appeal.
Yes, your
With a
lordships.
prayer for condonation of delay. And today we are in 2023, you are asking for prayer adjournment.
Lordships, kindly consider the lordships.
Can't take allow for this section 5.
Seven.
Take down. The respondent is not.
বলে দিচ্ছি এটা করে
7-8
বলে দিচ্ছি এটা হচ্ছে কলেজ ছাড়া হবে না সেজন্যই বলে দিচ্ছি 7-8
7-8 আছে।
তোমার ফিজের জন্য তোমার ফিজের জন্য কলেজের রেফারেন্স ছাড়া হবে কলেজে একটা অ্যাপিল করছে কলেজে একটা অ্যাপিল করছে বলতে আমি এখানে শুনে নিয়ে আসতে টুকটুক টুকটুক করে হতে পারে এটা কন্ট্যাক্ট
Yes, next matter.
Item number 8.
All these are appeared.
Malala. Whereas there is the principal order, two appeals were preferred, one by the college authority, another by the deputation. But this number is MAP number 1356 of 2016. It is required to be placed along with this matter because the entire allegation against the college authority. So the college is the main answering respondent. Today college authority is absent, so I have been requested by the learned advocate. We should let both the matter be heard. Let it be placed along with the MAP number 1356. They have disclosure.
You are appearing.
Appearing for the Vidyasagar University, respondent number 2.
You are the main contesting respondent.
No, not main contested. The college is the main contested respondents. The college is affiliated with the university, Vidyasagar University.
So, Mala, the college appeal is required to be.
Who is for the state of West Bengal?
State
You are representing the Vice Chancellor.
Vice Chancellor, Vidyasagar University.
Who is representing the state?
Mala, in a GP office only the respondents have been served with the notice. The copy earlier it was served upon
So,
the
Ms.
GP.
Samant, will you appear? Sorry?
My lord, this is a 2021 appeal, my lord. Someone is engaged in this matter. My lord, my humble prayer before your lordship, kindly give a notice to the learned advocate, my lord.
Who is appealing? He doesn't know.
Mm,
He has served upon the office of the learned GP.
It is in the
He can take a inquiry from the learned
government
government
leader's
leader.
office. There is
Because,
I will take information.
well, because this is regarding selection in the college and that is to be done according to the government dictum and government circular. So government's advocate's presence is required.
MAT 1356. We had together. Let you place next week. So that
This
in the
matter is
meantime, I
required
can
to be also.
Yes, notice has been served. Well, somebody is appearing from the college authority.
In spite of service, the instead of service, except the university, none of the respondents are being represented. Or any accommodation is paid for on their behalf. Next.
ঠিক আছে হ্যাঁ হ্যাঁ না না আমি করব নোটিশ দেখে দিও
Next.
Item number 9.
My lord, in this matter, my lord, only I am seeking a day's accommodation on behalf of the appellant. Mr. Vishwarup Bhattacharya is appearing on behalf of appellant, my lord. He has not come to court due to some extreme personal inconveniences. Only a day's accommodation, my lord.
This for the Union of
Lord,
India.
I appear in this matter for the IIM Joka, Indian Institute of Management Joka.
Union of India.
Union of India is. Lord, answering respondent is 2 and 3, that is Indian Institute. Yes. Yes. No, Indian Institute of Management, that is 2 and 3
So
respondent.
that means you are
Yes,
present.
yes, I am appearing.
And adjournment is paid.
One week.
My lord. Appearance. এটা তো আমি ওর হয়ে adjournment
Yes,
চাই।
yes, for the
ঠিক
list.
আছে আমি দিয়ে দিচ্ছি আচ্ছা ঠিক আছে
Item number 10. কোনটা? 9 হলো তো?
Yes, 10.
10, my lord, I am appearing for the appellant, my lord. I am appearing on behalf of the state respondents.
Yes, what is
My lord,
matter?
here, my lord, the issue in the instant writ petition, my lord, is, my lord, whether the benefit of higher scale of pay for acquiring higher qualification, my lord, which were given to the librarian of our rural libraries of Shivnath Kole's case, which was passed by the Honorable Apex Court, are to be extended to the writ petitioners or not, my lord. My lord, this issue has not been decided in the instant writ petition, my lord. My lord, the writ petition has been dismissed on a preliminary ground, my lord, that the petitioner was the guilty of forum shopping, my lord. Your lordship, kindly see the order, my lord. It starts from page 71, my lord. Relevant portion, page 75. My lord, may I read the order?
The issue is pending before the larger bench.
No, issue No, had no, my lord, decided that by has been law. decided, my lord.
One judgment was delivered by my lord and another is
My lord, it is with,
Dispose of on the basis of that judgment.
no, my lord, yes,
Yes,
but he is not covered by this judgment.
So if he's not covered, his repetition will stand dismissed.
He is not covered. I have the judgment, my lord.
Yes, give the judgment. He wants a dismiss, whatever decided on the basis of the, on merits, that is what he said. Oh, yes, yes. That went in review, I think so. It went for review. This was considered by us in review.
Yes, my lord.
Yes.
This was considered by us in review.
Yes, yes, yes. This judgment is also with me. I am giving the mother judgment. Kindly have a look to this, my
So
lord.
mother judgment is here.
Yes. প্রদীপ কারক তো?
ঠিক আছে। My lord, kindly have a look to paragraph number 107, 108, and my lord, kindly have a look next, my lord, 137, 138, 139. Only 5 paragraphs, my lord. First, my lord, 107. My lord, from which, my lord, whose benefit was given, my lord.
Yes.
My lord,
After this judgment,
Yes,
you
my
are
lord, my
entitled.
lord. Here, my lord, the petitioner was appointed as cycle peon in the year 1981, my lord. Thereafter, my lord, he acquired the qualification in the year 1989.
Yes.
But, my lord, he was appointed as a librarian of rural library on promotion, my lord, in the year 2004.
But that is covered by, I think, our review also.
Yes,
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 I
my
am-
lord. The
I am
cutoff
giving-
date is, my lord, July 1990.
no,
What
he
is
is not covered by this judgment, my lord.
No,
No,
I
no,
said
okay,
this
then-
covered by the judgment means by which we denied it. That was also the case of a librarian.
Yes.
It is my lord's judgment, my lord. দাদা এই কপি দিতে পারবো না।
Is it reported? We don't know.
আরেকটা দিয়ে দেবেন।
নাম্বারটা বলো তো FM এর 442
হুম। হুম।
And you signed the option. Are you covered by your judgment in
My lord, your lordship,
Mala Shannal?
my lord, I have not gone through this judgment, my lord. Your lordship kindly.
Pay down.
My lord, I am on different point, my lord. Kindly have a look, my lord. Give me some time, my lord. My lord, 107 of the judgment of Pradeep Karak, my lord. Must, my lord, kindly have a look. Benefit was given only the librarian of a rural library. And my lord, this is paragraph number 7. My lord, next, my lord, paragraph number 9, my lord. The benefit, my lord, which was given to the librarian of a rural library. It is also stated in paragraph number 109, and thereafter, my lord, it is specifically stated in paragraph number 137, 138, and 139. I am reading just only 139. My lord, however, those librarians who have acquired their qualification before the cut-off date, that is, my lord, 21st July 1990, are entitled the claim that they be treated at par with the librarians of Signatpur who were before the Honorable Supreme Court, as which I am stated, the benefit which was given only the librarians of a rural library who acquire the higher qualification within the cut-off date, that is 21st July 1990. This is the 33 ED, 33 ED in Millard. 7th of March 1990, this benefit was given 16.3. Lord, it is also stated in paragraph number 137 also, these librarians who acquired higher qualification after 21st July 1990.
He was not appointed as a librarian.
No, I am showing my lord. Kindly have a look to the appointment letter, the lead petition, my lord. Kindly have a look. This lead petition, the appointment as a cycle peon. My lord, cycle peon is, my lord, Group B class 8, and this benefit was given the librarians who are Group C. Scale benefit is different. When we acquire the higher qualification, it is at 1989, the Bachelor of Library and Information Science. When we acquire the qualification, at that time he was a cycle peon. He is not a librarian or real librarian.
But so this was a case where the librarians acquired higher qualification.
Yes, my lord, he is
But
not
he
a
was
librarian.
cycle peon.
Yes, this is a group B class 8. Cycle peon, my lord, he is acquired when he is, my lord, kindly, my lord.
My lord, I have not gone through your lordship's order, my lord. That has been passed subsequently. So I'm praying for my lord 1
No,
week time.
this is a
Yes, my lord, I have got my lord.
It's a fundamental point.
Yes, my lord, I have got
You are
my
not
lord.
coming within the zone of consideration, madam.
Yes, my lord.
I have got my
Don't
lord.
come on the zone of consideration,
My lord.
whether it is Shivnath Kole or Prakash Karat doesn't apply at all.
My lord, this issue has already been decided. I am handing over this judgment also. My lord, I am.
She has
Done.
come with all the judgments.
Yes.
Made our task
My lord,
easier.
my lord,
Yes.
in those matters, my lord, from the very beginning, I appeared along with those learned seniors. My lord, both the seniors are not. My lord, I am alone. I am just, my lord, page number 5. Kindly have a look, my lord. Wait. It was also argued by Mr. Majumdar, my lord.
No, but this was a single bench judgment.
Yes, my lord, single bench.
But there is no appeal from it.
No appeal.
Yes, exactly.
My lord, my humble submission is that, my lord, I'm paying for 1 week time.
I'll
My
give
lord.
you time. Yes, right.
Gentlemen.
The learned counsel for the
The attendant.
as junior library attendant on
It is also group D post, class 8.
on
On my lord, 17th June 2003.
17 June 2003. He was a group is corrected.
Yes, my lord.
We are returning the judgments. We need to নামগুলো দিয়ে দেবে কে?
May I get back the copy or with?
No, we'll almost লিখে দিয়ে ফেরত we'll get it back after it is been transcribed. ফেরত দিয়ে দিও। চল হ্যাঁ
কবে রাখলো পরের সপ্তাহে নামটা দিয়ে দাও
একটা কপি
না 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 ওরা ডবল কপি দিয়েছে ওইখানে আছে অসুবিধা হবে থাকলে
সেকেন্ড জাজের কপিটা এত মোটা মোটা কপি
এটাই তো
am saying not this week. In this matter, my lord, learned advocate, another learned advocate will appear, my lord. Kindly, not this week.
matter that petitioner has filed this writ petition is a non-teaching staff of a unaided madrasa. Now, lordship, the petitioners at the time of the DA inspection team conducted by the DLIT, the petitioner was
Well, you are filing an opposition. You have to file a reply.
reply already has been filed. Filed. Now, lordship, here in this case, why I am lordship harping, because this writ petition was dismissed by the honorable single judge. Now, lordship, against this rejection, that is the promotional from non-teaching staff to teaching staff.
Yes.
Now, lordship, when this appeal is pending, the secretary of the concerned unaided madrasa also moved a writ petition that for the upgradation of the post of the petitioner from teaching for non-teaching to teaching post. Now, in the writ petition, I am not a party. Now, this writ petition, petitioner suppressing all this material fact, this appeal is pending. Now, lordship, the secretary got an order from the honorable single judge.
By which upgradation is allowed now.
Now, there is a order of consideration. Consideration, the representative of secretary.
Consideration, then.
Now, lordship, challenging the same, we have preferred also and leave to appeal along with the stay appeal.
There is only one teaching staff.
Yes, yes.
There, and
Just a minute, yes.
We have also preferred a leave to appeal because when the grievance of the petitioner is
That
pending,
is not appearing in the list.
appearing in the list.
Item number?
140. This is my appeal.
Take out. And adjournment is. For upgradation from teaching to non-teaching staff.
Teaching to non-teaching.
From teaching to non-teaching. From teaching to non-teaching.
I shall file a reply, my lord.
You have not
In
filed a
this
reply.
matter,
This matter, lordship, my learned friend is not in this matter. He is on
I-
the other matter.
No, in the other matter, have you filed your
Yes,
reply?
the other matter there is till that not
My lord-
happened, lordship.
my lord,
Yes, you have filed a reply.
yes, my lord.
No, lordship, my learned senior friend is not in this present appeal.
I
He has filed the writ petition which I have challenged in the pending item number
That is
40.
140.
140.
He is appearing in 140.
Appearing in 140, lordship, he is also praying for time in present appeal.
In the present appeal, you are respond number.
No, he's a
The appellant, my lord.
So that's what I'm saying. He's the appellant in the present appeal.
আপনি দুটোই represent করছেন?
হ্যাঁ, দুটোই।
না, আপনি অন্য-
You have filed your reply already is on record.
Yes, my lord, I file a reply.
Both the matters are required to be heard
তুমি
together.
অপোজিশনটা একটু দিও।
হ্যাঁ, opposition দিয়ে দিছি।
আমাকে দাও।
Is,
So what's your-
other appeal is appearing in the list as item number?
140.
Both the matters are required to be heard together accordingly. We direct the department to list both the matters after 1 week.
প্রবাল কাজ
The
করছে
MAT
না।
এটা বলেছে
ওখানে ফাইলটা তো নিয়ে নেবে না।
হ্যাঁ, দাঁড়া।
তার সেখানে সবকিছু আছে।
Consideration order appearing in the days list as item number 140. As 140.
140.
My lord, in this matter, respondent is a teaching staff of that madrasa. And he is only one teaching staff. There is no teaching staff.
No, but if you are ready, we'll hear you. If you are not ready,
Yes, my,
so you decide what you will do.
yes, my lord.
We'll hear you,
Yes, my lord.
রেডি আছে
না না আমি এখন
but next time don't ask for any adjournment. Because this matter was adjourned earlier. We make it clear that no adjournment shall be granted on the agenda. No further adjournment shall be granted on the agenda. The original appeal in opposition filed on behalf of the respondent number 5 is taken on record. Who is this Mohammad Shahjahan? Who is he?
he is in teaching teacher in
No, you preferred an appeal. You said you preferred an appeal.
Appeal ওই 140
In 140, you preferred an appeal.
Lord, sir, I am Sajahan. I am the teaching post.
No, you preferred an appeal. The school has not preferred any appeal.
Lord, sir, the respondent number 5 in the item number 140 preferred and special leave to appeal along with the mandamus appeal.
So that writ petition, you are not supposed to be a party. Why you should be a party in that? You are not required to be a party in that proceeding.
So secretary has filed the writ petition praying for same relief as well as the present appeal.
school is suffering.
The school is suffering.
No, but who is for the madrasa? The learned counsel for the
Lord, sir,
parties
the
are
state
directed-
is the principal
Yes,
response.
Ms. Shamund, are you appearing in this matter? 11 with 140.
Lord, sir,
I am not appearing.
I think I'm a last order. Last order to the.
Lord, sir, item number 140, I'm told that learned advocate Mr. Bhaskar Boishu is appearing for the state.
Same matter.
একটা কপি অফিস
No, 140, no, it's an order to the.
অপোজিশনের কপি আমি তো সব প্রবাল লেখা দেওয়া আছে আপনি দিয়েছেন।
লাল রতন Ms. Shamund. If Mr. Bushu is appearing,
might not kindly direct them to serve the opposition copy.
no, leave to prefer an appeal, we cannot, we have to hear them and then we have to decide. So Mr. Bushu is not here, of course. But Mr. Bushu must be, if he is appearing, then he should be today here in this
Lord, sir,
matter.
in item number 140, learned advocate Mr. Boishu appeared.
No, but here also Madrasa is a party.
Also, they have sub করেছেন আপনারা মাদ্রাসাকে?
Have you served the Madrasa?
মাদ্রাসাকে সাব করেছেন?
কোনটা
মাদ্রাসাকে
না
সাব
না না
করেছেন?
কিছু তো আমি আগে সার্ভ করেছিলাম মাদ্রাসাকে।
করেছেন তো?
হ্যাঁ হ্যাঁ আগে করেছিলাম যখন ওই কেসটা
Madrasa is not the representative. So if Mr. Bushu is there, then in addition to that, he also accepts, he also, huh?
I will inform Mr. Bushu to
If
appear
Mr.
in
Bushu
this
is there,
matter.
no problem. If you are also there in the matter, there is no problem.
I have no problem. I have no problem, but copy will be served. I have nothing.
Stop. Since the Both of you shall serve.
He is saying he has already served Mr. Ghosh.
Doesn't matter, you also serve.
No, my copy also I will serve. Lordship, আপনি এটা কপি সার্ভ করে দেবেন।
আচ্ছা আচ্ছা ঠিক আছে।
Yes.
Well, this is my appeal. Actually against the judgment and order, and my lord, prayer of the petitioner was allowed in part regarding postgraduate scale as well as the, my lord, shifting the social science group to Bengali. Now, my lord, what I only find this appeal, here is a delay, my lord, to 88 days.
This is an
Delay.
appeal against the contempt order.
Contempt order.
Order of contempt, my lord. Contempt has been dropped.
Lord, my lord,
Appeal has been preferred.
my lord, here, my lord, allowed in part regarding postgraduate scale as well as the, my lord, shifting back. Only, my lord, the other.
Contempt dropped is,
My lord, section.
But yeah, here is, my lord.
it's not an appealable
Not
order.
applicable.
No. But my lord, here, my lord, the
Contempt
last,
dropped is not an appealable order.
my lord, yes, my lord, Ranesh single judge, only,
Contempt dropped is not an appealable order. So why you are arguing? Straight down.
my lord, only, my lord, for the, there is a direction to, my lord, it is cause of action to file the appropriate bench. My lord, last year, lord, there, fresh cause of action, which is not conscious of the repetition.
That is also given in the order itself.
The order itself.
The delay of 255 days.
Next.
Yes, sir.
No, thank you.
Yes. Yes.
My lord, I am appearing for petitioner. Against my lord, refusal of appointment under died in hardness category. My lord, lordship will find the order. I have annexed the trial court's order, last annexure, my lord. Now, my lord, it has been rejected on the ground that pension which I am drawing is higher than Group D staff. Now, my lord, very short point, my lord. Your lordship will consider and your lordship will decide this issue. If I straightway come to my lord page 52 of the certificate with the marking. Oh, certificate. My lord, looking at certificate copy. My lord, then your lordship will come to paragraph 12 of the judgment. There your lordship will find, my lord has got it. My lord,
Financial hardship.
financial hardship, right. My lord, that has been explained in relation to income of a deceased teacher or non-teaching staff consisting of up to 5 members in his family shall mean an amount of income less than the initial gross salary of Group D staff of the state government at the material point of time. For computation of income of such family, and income of an amount earned by each family member from any other sources than Provident Fund gratuity, and 40% of family pension of the first 7 years, or upon attainment the 67 years of age of the deceased teacher, had he been alive, whichever is earlier at the material point of view, shall be taken into account. Now, my lord, that is where they have shown the calculation. Next page, page 53. That is, my lord, family pension at the enhanced rate, page 53. Sorry, next page, my lord. So paragraph 14, they have shown the calculation. That is, my lord, 15,550. And my lord, adding everything, it comes to 22,688. And what 40% have been deducted according to that provision. And gross salary, 10,860. Now, my point is this. In a family pension, your lordship will kindly look at this. Family pension and enhanced family pension are different. Because if I am alive, if I work up to 60 years, then I will get family pension. Pension. And after my death, he will get family pension, he or she. And enhanced family pension is well provided for premature death, in case of premature death, and 7 years is added. Maximum 7 years or 67 years, whichever is earlier. Now, lordship can see, in affidavit in opposition, they have annexed a document. Well, a copy is with me. Page 14, page 14 of affidavit in opposition.
Yes.
Page affidavit of opposition. তোমাদের
আমাদের কিন্তু এটা মধ্যে
হ্যাঁ?
আমার কাছে নেই।
নেই, এই ওকে একটা এক্সট্রা কপি দাও না।
আপনি
ওর
opposition
কাছে
দাও।
নেই। আচ্ছা, তোমার কাছে
record.
It is before the trial court probably they're placing.
এটা কি ট্রায়াল কোর্টে দিয়েছিলে?
Trial court affidavit. Trial court.
এটা ট্রায়াল।
You have not annexed the affidavit in opposition.
Oh, I see.
You have filed your reply also.
Yes, yes.
My lord, affidavit in opposition in the court, my lord.
Oh, I think it was filed in a trial court.
So you need to file
Yes,
the-
yes. I am.
You need to file the opposition reply they have filed.
They have filed reply.
So you file two said, only then we can consider.
No, my lord, this is not before the appeal court.
No,
It
this is no, my lord.
I have
Correctly,
followed what is said.
I will have to file 2 copies
Of the opposition.
and also 2 copies of reply.
May be a copy be supplied also to me because we have got no copy of that.
Take down.
My lord,
But what is your point?
My point is this, my lord, that my lord, if I place it before the lordship, I will be able to explain it before lordship, my lord, try to explain. এটা একটু দেবেন জজ সাহেবকে 1 মিনিট মানে only 1 copy I am handicapped and extremely sorry because when a family pension your lordship will find page 15 enhanced family pension is not a family pension. Page 15, my lord, kindly look at page 15. They have defined, they have given. My lord got it, my lord, page 15.
It's merged and it's not clear. It's not very clear.
No, no, by the left-hand side.
Yes, but it's merged. Can't read it properly. Yes, enhanced family pension.
Serial number, my lord,
After 5.
after 5, right.
Yes, so what is this document?
Enhanced family pension and your lordship will find normal family pension. So family pension means, my lord, normal family pension. Because well, I will get that amount for the lifelong, so long I will alive. But the question of hardship, financial hardship is considered. Now, my lord, that is family pension should be taken into account, not enhanced family pension. And family pension should not include any other allowances. Because when I've considered, and there are other judgments also, I will place before lordship, my lord. My lord, this is the point I want to urge before your lordship, my lord. That a compassion account appointment is, my lord, special consideration of the government.
No, you had a premature death.
Premature death.
So that is why if you are a premature death, you will be getting an enhanced family pension.
Enhanced family pension for a limited period.
Yes, but that
Not
is a
7.
scheme. That's a scheme.
That is the scheme.
So otherwise you will not get a family pension at all.
Yes. And my lord, also it has been said that in case of premature death, I will get enhanced family pension.
That explanation, whichever is
Yes,
there,
yes, yes, my lord.
it said 40% of the family pension of the first 7 years.
Right.
So 40%.
40% will be deducted.
40% has been deducted.
But family pension becomes, my lord, much less. My submission is this, that
No, see, because of the premature death, you are getting the benefit of enhanced family
enhanced
pension.
family, right.
Otherwise, you will get the family pension.
No.
So once you get this amount, that may be a substantial amount for the purpose of determining that whether you are able to come out of
Financial hardship
Yes.
for the time being.
So that is why it says that if it is a group D employee or group C, whatever is there, the
Group D.
clause says that if it is more than the basic.
Group D.
So calculating paragraph 14, he had made the necessary computation. Family pension of the deceased teacher was higher than the gross salary. Is higher because of his premature death.
Right.
So exactly the amount what he is receiving, that has to be considered for the purpose of determining your compulsion appointment. So if it is more than the gross salary of the group D employee, then it cannot be considered.
Well, then, my lord, I will rely upon two judgments.
Yes.
This is, my lord, family pension. This is also, my lord, family pension. Enhanced family pension is, my lord, family pension.
Yes.
So my lord, enhanced family pension for a particular period. Similar widow. He will get enhanced family pension for a period of 7 years.
Yes, no problem. But that may be a consideration for deciding
Whether I will
whether you
get a service
compulsion
or
appointment or not.
whether I will get a service or not.
Both are different aspects. One is your statutory right. Other is
Compassionate appointment and
for the purpose of compulsion appointment, whether that will be the
that will be considered or not. That my lord, I will explain to your lordship, my lord. I will place my lord 2-3 judgments. Where it has been held.
Please give us.
But family pension.
And then you have not challenged the rules also.
No,
2000 rules are not under challenge.
Rules are not under challenge. No, might not be necessary. Explanation, my lord, if I can satisfy your lordship, my lord, from Bolby.
Prima facie it appears.
But
two
your lordship
considerations are
correct.
there. One is your entitlement to pension of enhanced family pension.
Right.
That is by law you are provided by rules. The other is when it goes for compulsion appointment, the court has to find out whether the financial yardstick which is there, it fulfills your requirement or not. If the policy is that upon computation, if it appears that it is more than the gross salary of a group D employee, then you are not entitled to. Because you cannot have best of both the worlds. You're getting a higher family pension because of the premature death. At the same time, you ask the authority to discard it for the purpose of consideration of your compulsion appointment. Mr. Moitra. That's the problem.
That's but
and this rule is also not under challenge.
The rules, my lord, but my lord, the others, other aspect is this. That my lord, hardship not for 7 years.
No.
But scheme is different. When I will go beyond that.
Hardship is for because as you know, that this is not the normal rule. It's a deviation.
No, this is not the normal rules.
So if it's a deviation, that's why the scheme is made. Now, when the scheme is made, there are two aspects. One is if the financial benefit is given to you, there are provisions which say that even if you accept family pension, still your case for compulsion appointment can be considered. It's possible. There could be a scheme. There could be a scheme which says, now, if the family pension that you receive is of such an amount which is more than the say group D employee, you are not entitled. So then you have to challenge the scheme to that effect. Because compulsion appointment is not a vested right.
No, vested. I don't say
no,
that.
I'm saying that. So what you are challenging is the basis of this. Unless you challenge the basis of this, that this discriminatory or there is no intelligible differential between the two.
But that I will second thing I will place.
So that's the reason. But going by this, there is a nexus because if you receive a financial benefit, the government thought that if this amount is received, then under the scheme you are not entitled.
No, whether the scheme is valid or
that is not under
that is not.
But you are saying that for the purpose of computation, for the purpose of
consideration is absolutely, my lord, without having any basis. Because of this reason, this scheme has been framed. Of course, again, challenge of scheme comes for. But when your lordship can extend it, expand it while your lordship will consider this. Now, my lord, whether enhanced family pension and family pension, there is one difference. There is distinction or not. Number one. Number two, a person surviving person, my lord, dependent. Whether, because my lord, how long he will remain alive, nobody knows. Now, my lord, for that reason, to protect his family, my lord, compassionate appointment is offered. Now, a scheme is framed to this extent that one should get, one will not get family appointment if he gets pension, family pension more than group D staff. No matter what is family pension, whether enhanced family pension is a pension, family pension, or family pension is the actual pension. That your lordship will kindly decide. But even if I don't, my lord, challenge the rule, But this part your lordship can consider and decide. Because for enhanced family pension and family pension, definitely, my lord, there is difference. And your lordship will find, my lord, that family, they have mentioned enhanced family pension, NFP, and normal family pension, EFP and NFP. But these are two different aspects. To this, my lord, I will argue, my lord, I will try my best to satisfy your lordship. I will place also two, three judgments. One, your lordship, very well-known judgment, that is Bolbir Cow.
Bolbir Cow was considered by the learned single judge.
But my lord, I will place paragraph, and also, my lord, a division bench judgment of this court, that your lordship will kindly also consider, that I have not, that relying upon Bolbir Cow, that judgment has been decided. I will place that judgment also. When I have not gone through the judgment, I got it later on. I did not go through it. Lordship will kindly take up on Wednesday.
Next Monday. These are all next Monday then.
Next Monday.
Take it down.
My lord, the copies, my lord,
Kota.
supplied. Oh, copy to take to the
Josh have a copy to file with them. Well, shall I file lower courts?
The appellant shall file
and
yes.
No. এটা আমাকে দিলে যে লোয়ার কোর্টে ফাইল হয়েছে, ট্রায়াল কোর্টে ফাইল হয়েছে, বলো আমি তো পড়িনি, আমি পড়েছি, আমি জানি এই কোর্টে ফাইল হয়েছে এফিডেভিট। জেরক্স করে নিয়ে জজ সাহেবের দুটো।
Item number 15.
Writ petition copy দুটো। My lord, shall I file copy of the writ petition?
I think that is already annexed.
That is annexed. সেই জন্য বলছি writ petition is
তো সকালে হয়ে গেছে 1 week after 1 week করা হয়েছে। Item number 15.
Malota, in item 50,
Item number 40.
Malota, I am seeking Malot 10 days accommodation, Malot, because I have lost Malot 2 can Malot that is there in my
You lost.
Malot, I misplaced Malot. Sorry, sir. That wrong word I have used.
Yes, sir. On the prayer of Mr. Abhishek Prasad, the land counsel for the appellant, the matter is adjourned for 2 weeks. Next.
My lord, item number 14, my lord, matter was moved out of turn, my lord. Item number 14, I am appearing.
14.
This was not called, my lord.
Morning, it was mentioned that the learned advocate has not come. আচ্ছা ওনার নামটা রেকর্ড করে দিও 14 আমাকে বলে দিও ওনার নামটা কি
ওনার
It
নামটা
was mentioned in the first call.
Adjourn for 1 week, my lord.
না কি হয়েছিল ওটা কি হয়েছিল 14টা 14 না আপনি তো নোট করেছেন
One week adjournment.
ওই অর্ডারটা ওনার নামটা তাহলে দিয়ে দিও so in the first call he mentioned so,
My lord.
16.
yes who is for the state
I'm for the respondent council.
I'm for the appellant, my lord.
You're for the state.
I'm for the respondent council, my lord.
Who's for the state? Ms. Samant, are you appearing?
My lord, subject to correction, Mr. Supriyo Chattopadhyay probably.
He was here.
He was there.
Yes.
Well, I'm for the appellant, my lord.
Yes. Yes.
All of the improved order, may I place, my lord? Page number 232, my lord. May I place the
No, but if he was appointed, we asked you for instruction.
My lord,
We asked you for instruction last time. Mr. Sharnal appeared.
my lord.
If he were to be appointed in 1997, because he has to file 3 writ petitions.
My lord.
And ultimately he got his.
My lord, after the order of just, my lord, the division bench,
my lord, may I place the
Just,
Lord.
my lord, your lordship, my lord, after the order of just the division bench, my lord, presided over by the Honorable Justice Girish Chandra Gupta as the then was, my lord. My lord, after this, my lord, there is
Which order?
my lord.
One 126 যেটা অর্ডারটা তুমি বললে আর কি 26টা প্লেস করো 26 126 ওই ওই
না না এর আগে আছে order আছে।
মানে ওইটি হচ্ছে ওটা রিভিউর অর্ডারটা
My lord, your lordship kindly, my lord, come to my lord, page 118. না জোসেফ দেখুন যখন গিরিশ গুপ্তের প্রথম অর্ডার রিভিউয়ের আগে এটা 3 বছরের যদি 97 সালে চাকরি করতে 3 বছরের presidency of service হচ্ছে যেটা স্টেটের
Yes.
My respectful submission to your lordship. Petitioner was got the letter of screening test in the 1987 for the post of assistant teacher in primary school at Howrah district. In the 1993, he got the interview letter, but he did not get the appointment letter. Appointment was issued, who was less awarded marks. We said incumbents got the appointment letter. That is why petitioner and others moved an application before the High Court, Calcutta, in the 1996. An order was passed on in the 1997. Well, your lordship kindly see page number 94, my lord. No, my lord, I am sorry, my lord. 161. My lord, you also kindly see 161 for a moment, my lord. In my stay
No,
application.
where is your letter of appointment?
My lord,
Where is your letter of appointment?
your lordship kindly see my letter of appointment. I have placed everything. And that is why my respectful submission I have. Page number 78.
So you knew that when you were appointed.
My lord, in this regard, my respect.
No, you knew that when you were appointed, you will have a service tenure of 7 years.
Lordship. So my respectful submission, in the 1997 order was passed. I have already mentioned my before lordship.
Have you challenged this letter at page 78?
My lord,
Have you challenged this letter of page 78?
no, my lord.
Then
My respectful submission, but only for a moment, your lordship, before passing any order, only my respect, for my satisfaction, my lord, your lordship can see, self-same cause of action, your lordship, for a moment, my lord, for a moment, self-same cause of action, one litigant came before the order.
maybe we don't.
Only my Supreme Court judgment, before passing, only my respectful submission, your lordship, for a moment, before passing any order, 3 years qualifying service, I have prayed as because if another incumbent got the appointment letter after 60 years, after preparing an appeal by the state government, writ petitioner, another subject matter, self-same cause of action. So, my lord,
The appeal is arising.
my lord, your lordshiply, I have,
It appears that the appellant was
my lord, only my satisfaction, your lordshiply, hear my point.
on an ad hoc
Before to submit my subject, when the petitioner did not get the opportunity for service for 10 years, how, on what basis he was appointed? This, my humble respectful submission, as per rules and regulation.
It's a closed chapter for you. You may have a good case, but after Justice Girish Gupta's order, you have no case.
My Manoj Justice didn't, in review, the,
Yes, pension if you are entitled to, that's all.
my lord, only my respectful, my lord, only my respectful submission,
Nothing is.
45 in the age of 45.
Sorry.
আমারটা দেন স্লিপ একটা হ্যাঁ হ্যাঁ আমি রেকর্ড
For the appellant, Mr. Pushpal Chakraborty, sir, is appearing in this matter, but he is suffering from fever. I'm paying for 1 week accommodation.
I'm for the state in madam.
Sure. Is submitted on behalf of the app.
So on the next day, we will file.
Yeah, I did it for 2 weeks.
15 minutes.
So 3 weeks. 2 weeks. 2 weeks. You have filed your notes?
No, my lord, I will.
Why?
Well, we will file, my lord.
The part is the time to file. List of days and notes are by the parties is extended by 1 week from date. If you don't file within 1 week, will not release the matter.
The
Yes,
matter will be fixed at 2, as it was.
yes, call the list.
Let me.
165.
Yes,
I am appearing for the writ petitioner respondent number 1 to 5. I am led by Mr. Ashok Kumar Banerjee.
I am appearing for added response. Added response.
It should be 23.
where the list of dates and notes of argument. This order.
We have prepared. We have prepared.
Yes.
It is just.
Yes, Mr. Gupta, where is your list of dates and notes of argument?
In fact, I was not told of this.
Yes, the order, we dictated the order.
Mr. Balaj.
Because the order says so 12th July.
Yes.
Your junior, if he is so callous, that nothing can be done.
In the list, it is indicated. And in the order also.
You should have taken this responsibility. That is why you have an advocate. Yes. You file your notes, then we'll take up the matter. Otherwise, not. We are not granting it. Take down.
Or possibly, my lord, list of dates may not be necessary.
File your notes. Direction is there, that has to be complied, Mr. The time to file.
Uh, 1 to 5.
1 to 5. On number 1522. Devashish Kundu and
So Tapan Mukherjee was appearing for the state.
I did respondent 24.
Yes, where are your notes of arguments?
I appear for 24 to 26 added
Yes, but where are your notes of arguments?
Mr. Mrs. Koeli Bhattacharjee is appearing for the board.
যেহেতু ওনারা অবশ্য লিস্ট অফ ডেটস করেননি যে এক্সটেন্ডিং অর্ডার লাস্ট অর্ডার তাই বলা ছিল যেহেতু আজকে নেবে না কালকে অ্যাটেন্ড করছি আমরা করেছি আমি দিয়ে দিচ্ছি
So we have prepared the list of dates, why not?
Non-compliance on our part.
আর লিস্টে বলা প্লাস অর্ডার তো সাবমিশন করে দিয়েছি আর স্টপেজটা দেওয়া আছে
আমাদের থেকে
একটা দিয়ে দিয়েছি এটাই ব্যাপার।
আমাদের তো করছে না
হ্যাঁ হ্যাঁ মেমো অ্যাপিলটা কোথায়? মেমো পর্যায়ে থাকে আর যেটা হয়েছে
number 15 to 22. That's why Mr. Partition.
Where is your notes?
At the time of getting your lordship's order, I could not. And after subsequently, I came to know from the order sheet that it has been, my lord, I am paying for 2 days time.
একে
I might want to go for better discussion.
আরে মেমোতে যদি কপি নিয়ে একটা মাইলটা বসে আছে
অরিজিনালটাকে আগে এডিট করা হচ্ছে রেকর্ড করছি কিনা সেটা দেখার জন্য
সব রাখছি
হস্টেল ল্যামেন্ট করেছিল বললো বলে দাও না হস্টেল ল্যামেন্ট করেছো বলিয়ে দাও না Where did respondent research? It's police teaching staff. Yes, supporting. ছবি আছে সেটা বলে না সেটা বলে না ছবি আছে অতটা জেনে নিয়েছে মনে হতো
আমাকে তো কপি Stop this session.
আমাদের উপর একদিন তিনশো তো আছে অর্ডার শিট দিয়েছি
ঠিক
ঠিক আছে, এটা লাস্ট লাস্ট এটা ম্যাথই চুরাশি শুনে সরিয়ে দাও আগে থেকে কি যেন লাগিয়ে দিয়েছে ছিলেন 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 সরিয়ে দাও অবশ্যই
Yes, Mr. Gupta. Yes. What is my purpose?
This was a school established by National Thermal Power Corporation, a Bengali medium school, for the purpose of the benefit of the of the words of its employees. Because NTPC there was no school nearby, it was established for that purpose. Subsequently, of course, other students also started getting admitted to this institution. And the school obtained recognition from the Board of Secondary Education. There was a condition that the pay of the staff shall be as per the as given by the state in respect of schools aided by it. That was there. Now, we were not in a position, my lord, to run the school for long, because we didn't have really the knowledge of administering an education institution. We approached the state government to take it over, including land, every building, etc. The state refused to do that. Then we approached the DAV school authorities, who agreed to run this school. And DAV engaged certain other teachers, teaching and non-teaching staff also. The school was functioning for some period, but then since more schools came up in the region, and this was a Bengali medium school, in course of time, there was no students who are getting admitted to the school, and as a result of which, the school had the number of students with which it was not viable to run any school. And there was at a point of time, came, when there were only 5 students together in all the classes. Total number of students in the school was 5. And at that point of time, the school was closed with the order of passed by a division bench of this Hon'ble Court. The school was closed. Now the question on which the writ petition was filed in 2014 was on the basis of a claim for the same salary, some same pay scale as provided by the other school sponsored or by the government and which are aided schools. Now, with regard to them, the Division of Pay Allowance Rules 1990, then 98, 2009, like that, there are several ROPA rules came and they were asking for the benefit under those rules, fixation of pay under those rules. The school was not in a position to do that. They were referring to the condition of recognition where the board said that the school will have to pay salary as per the government scale. Now, the question before the lordship is whether it is the NTPC has the liability to pay this as per government rates. Now, there was another litigation previously where the question, my lord, came up. Question before the court was not regarding salary, etc. The question was whether they are employees of NTPC or not. My lord, a learned single judge held that they are not employees of NTPC. They were employees of the local management committee and not staff of NTPC. They were claiming benefits of NTPC, etc. The court held so. And in the appeal, my lord, they did not proceed with the appeal. They filed the appeal, they did not proceed with it, and the court dismissed it as infractuous. Now, here the question is whether they are entitled to this or not, a government scale or not. My lord, I have with me one judgment, my lord. This is 2011 Supreme Court, where the Supreme Court held, my lord, that a private school unaided is not required to pay as per government rate. My lord, and there also this condition was there in the condition of recognition that the school will have to pay as per the government rate. The court said that unless there is a law or a general order, general executive order requiring this, merely a condition in the order of recognition that you will have to pay as per the government rates, that will not, my lord, create any liability on the school to pay at such rate. There is one judgment, like I shall cite before your lordship, 2011. This is 2011, volume 13, Supreme Court cases, page 760. আমার কাছে বইটা তো আছে। Huh? 23 to 20. Huh? My lord, if your lordship gets it, my lord, kindly come to paragraph 16 first, 1-6. In our considered opinion, the division bench of the High Court has rightly held in the impugned judgment that the teachers of private unaided minority schools had no right to claim salary equal to that of their counterparts working in government schools and government aided schools. The teachers of government schools are paid out of the government funds, and the teachers of government aided schools are paid mostly out of the government funds, whereas the teachers of private unaided minority schools are paid out of the fees and other resources of the private schools. Then kindly come to 23, paragraph 23. Paragraph 23. We also do not think that the court could issue a mandamus to a private unaided school to pay the salary and allowances equal to the salary and allowances payable to teachers of government schools or government aided schools. This is because the salary and allowances of teachers of private unaided school is a matter of contract between the school and the teacher and is not within the domain of public law. In Shushmita Basu vs. Baligan Shiksha Samiti, the teachers of a recognized private school known as Baligan Shiksha Sadan in Calcutta filed a writ petition in the High Court of Calcutta praying for issuance of writ of mandamus, directing the authorities of the school to fix the salary of teaching and non-teaching staff of the school and to remove all the anomalies in the scales of pay as recommended by the Third Pay Commission, as extended to other government aided schools and government schools. And this court held that in the absence of statutory provision, no such direction can be issued by the High Court under Article 226 of the Constitution. Then 25, where a statutory provision casts a duty on a private unaided school to pay the same salary and allowances to its teachers as are being paid to teachers of government aided schools, then a writ of mandamus to the school could be issued to enforce such statutory duty. But in the present case, there was no statutory provision requiring a private unaided school to pay to its teachers the same salary and allowances as were payable to teachers of government schools, and therefore a mandamus could not be issued to pay to the teachers of the private recognized unaided schools
the same salary and allowances as were payable to teachers of government institutions. Then but then Milord 26, paragraph 20, in Krishnamachalu versus Venkateshwara Hindu College of Engineering, relied upon by the Learned Council for the appellants, exhaustive instructions were issued by the government that the scales of pay of a laboratory assistant as non-teaching staff of the private colleges shall be on a par with the government employees. And this court held that even though there were no statutory rules, the laboratory assistants as non-teaching staff of private colleges were entitled to the parity of the pay scale as per the executive instructions of the government, and the writ jurisdiction of the High Court under 226 is wide enough to issue a writ for payment of pay on a par with the government employees. In the present case, there are no executive instructions issued by the government requiring private schools to pay the same salary and allowances to their teachers as are being paid to the teachers of government schools or government aided schools. Then 27 is very, very important, Milord. We cannot also issue mandamus to respondents 1 and 2 on the ground that the conditions of provisional affiliation of schools prescribed by the Council for the Indian School Certificate Examinations stipulate in clause 5B that the salary and allowances and other benefits of the staff of the affiliated school must be comparable to that prescribed by the State Department of Education, because such conditions for provisional affiliation are not statutory provisions or executive instructions which are enforceable in law. Similarly, we cannot issue a mandamus to give effect to the recommendations of the report of Education Commission 1964-66 that the scales of pay of school teachers belonging to the same category but working under different managements, such as government, local bodies, or private management, should be the same, unless the recommendations are incorporated in executive instruction or in a statutory provision. We therefore affirm the impugned judgment of the division bench of the High Court. Therefore, my Lord, even though there is a condition in the recognition order, school's recognition order, that the teachers will have to be paid or the employees have to be paid as per the government rates, that will, my Lord, not be enforceable. And a private school unaided is not required to pay as per the government scales, because this is a private contract. And that this part, my Lord, this contractual part is not enforceable in a writ petition because there is no public duty involved in it. My Lord, there is a very recent judgment on this, my Lord, in 23 this year, which says, my Lord, that in respect of an unaided private school, concerning the service matters, no writ lies. Regarding the in respect of service, which is not governed by any rules. Not here, this pay aspect is not governed by any rule or even by any executive order, general executive order.
Recognition is given under what provision?
Lordship,
Recognition is given under what provision?
recognition is granted by the West Bengal Board of Secondary Education
Provision.
under the West Bengal Board of Secondary Education Act.
Is given by the state.
Recognition is given by the state. That is not
In exercise of any statutory power?
Page 53, that is annexment.
that's the recognition order.
Only
Recognition.
In exercise of any statutory power?
No,
Recognition is in exercise of any statutory?
Not to my knowledge.
What is the provision? Where is the recognition certificate?
Milord, if your lordships kindly take page 53, that is or 53A, that's a better copy. 53A.
এটা কি দিচ্ছ এটা? আমাকে স্টিকার দাও, স্টিকার।
Page 53, as your lord is kindly got it. This is, my lord, dated 11th of May 1989.
No, this power which the West Bengal Board of Secondary Education is exercising under, it must be on some basis of some
That is,
provision.
so far as affiliation or recognition is concerned, that is given by the board.
Under
Now, my lord, the
exercise of-
board functions under the West Bengal Board of Secondary Education Act 1963.
Yes. So
But what should be the conditions of affiliation?
also
That is
recognition-
not a statutory prescription.
No, recognition, this power is exercised under a statute for the purpose of recognition.
Yes.
So if I make an application to you and this recognition must flow from my, of course, if I do not have the power, I cannot give you recognition. So that is in discharge of my statutory function.
True.
So if in discharge of my statutory function, I given you something on that basis and you accept it because there is nothing to show that you have been coerced because you yourself have made an application. And in any event, you are Article 12 under the Constitution of India. Cannot be treated at par with any institution under Article 30 of the Constitution of India. So you made an application.
But I beg to join issue in one aspect. I may be an Article 12 organization, all right. But that does not mean, my lord, subject to correction by your lordships, that for each and every aspect
So in each and every
of each
aspect
and
may not
every
be-
work I do,
if it is that
my lord, if that job, if the job I do is something, my lord, not related to the purpose for which I exist, it is not something which is not prescribed by any law. My lord, if I voluntarily set up a school for the benefit of my employees or their wards, then my lord, that is not on the basis of any statutory obligation. What I do, my lord, is purely contractual, and on that contractual aspect, I approach the board, I get the recognition. My lord, everything is done on the basis of not on the basis of any statutory obligation which I have under the law. So far as setting up of the school or maintaining the school is concerned, I am not obliged, my lord, Article 12, my lord, I am an organization under Article 12, but this part of the job is not amenable to writ jurisdiction. That is what I submit.
absolutely fine. Now, you got a recognition on the basis of certain condition. You gave an undertaking. On the basis of that undertaking, the teachers were recruited or they are existing. So you just opened a school. So undertaking was that teachers will be paid, whoever you recruit. They should
The
have
employees will be paid as per government rate.
as per government. Question is this, that can you resile from this or not?
Now, my lord, may I submit this? Whenever your lordships are speaking of an undertaking on our part, my lord, it straightway proves that it is pertaining to the field of contract. Now, so far as the contractual obligation is concerned, even if there is violation committed by a party to the contract, that cannot be the subject matter of a writ petition. My lord, that is what I read from the judgment of the Supreme Court. That when it is a contractual obligation, but they are also in that reported judgment I had just cited, 2011, volume 13. They are also, my lord, there was a recognition granted by the Indian School Certificate Examination Authorities. There also that recognition was there. There also, my lord, a condition was there that the employees will be paid as per the government rates. That condition was also there. Therefore, that undertaking was there also. In spite of that, my lord, the court says that in respect of a contractual aspect, where no public duty is involved, it's a purely contractual field. So far as this aspect is concerned, it's a purely on a contractual field. Private law element is involved only. Therefore, it is not amenable to writ jurisdiction. So far as this service condition is concerned, in that reported judgment, my lord, I draw a cue from that same judgment and submit before your lordships that here, my lord, the situation is identical. This school has also obtained recognition on the basis of that condition, on the basis of, let us assume that on the basis of undertaking also. but then subsequently the undertaking is not honored, then what will be the consequence? It is a non-performance of a contractual obligation.
It may result you losing
And I'll submit, my lord, that this is non-performance of a contractual obligation by a private body. This is private body so far as school is concerned. It's a private body, and particularly if there is where there is a judgment of this honorable court saying that they are not employees of NTPC. They are the employees of the local management committee. But without going into that aspect, even otherwise also, my lord, for NTPC employees also, I mean, sorry, for these school employees also, this contractual obligation of NTPC is not enforceable in a writ petition. Factually, my lord, the number of students was so small that the school was not in a position to continue. As I said, my lord, lastly, the situation was such that from classes 1 to 10 or 12, there were a total number of 5 students. As against that, my lord, there were 15 teachers.
Class 6 to 12.
Oh, for classes 6 to 12, I stand corrected. From classes 6 to 12, only 5 students. Now, my lord, and there were teachers, my lord, maybe 12 or 15 teachers plus non-teaching staff for 5 students only. My lord, even in 2009, the state government did not say, my lord, the state government was possibly aware that this is not a statutory obligation on the part of NTPC. If your lordships kindly turn to page 552 in the volume 2, the state government, even in volume 3, the state government even in 2009 did not require us to comply with ROPA. Page 552 in volume 3. Five two in volume.
Fair or bitter, sir?
No, 573 got that.
Yes.
এটা হয়তো এটা অ্যানেক্সাস ছিল, এটার পরে হয়তো এটা অ্যানেক্সাস। এটা হয়তো পেজটা অ্যানেক্স হয়ে গেছে, 54 এর পরে হয়তো কন্ডিশন বলে করে ফেলা হয়েছে। পার্ট অফ বলা হয়তো কন্ডিশনটা ছিল, এটা হয়তো লাগছে। এটাই ঠিক, মানে এখানে সেকেন্ড পেজটা দেখাচ্ছেন 552
My lord, 552, my lord, I have referred to. My lord, kindly come to 552 the last paragraph. However, I request you to please come to an amicable settlement with the teaching and non-teaching staff of the school. It is coming from the government school education department. Regarding payment of fair or better salaries as may be acceptable to them in the interest of the school children and to maintain peace and healthy atmosphere. My lord, government also does not say that you enforce this ROPA. My lord, as late as in 2009, government also doesn't say that. Now, there are one other document, my lord, which your lordship may kindly look to. That is at page, my lord, 573. 573. Your lordships will notice. This is, my lord, same thing as page 53A. Are your lordships on 573? This is, my lord, if your lordships kindly take page 53A or 53. This is the same document. But the at 574, at page 574, lordships will kindly see the conditions which is not there appended to this letter in page 53.
Yes.
No, no. It has written part. Your lordships are on page 573. This is part of the board's affidavit. Page 53, I had shown to your lordship, is part of the writ petition and annexed to the writ petition. Now, this same document is in the board's affidavit at 573A. Now, kindly turn over, kindly come to page 574. In 574, these are the conditions of recognition. And these is the board may be able to clarify. I may not be able to assist your lordship properly. At page 574, the conditions of recognition, number 7, serial number 7 is struck off. At page 574, serial number 7 is struck off. And this is 7. Serial number 7 is struck out.
Struck out. Where do you get it? Page?
Page 574.
574. The stock of library books.
No, 7 is teachers and non-teaching staff. should be paid their salaries and other admissible benefits according to grant in aid rules. This clause is struck out. This we get from the board certificate. This condition, this particular page is not in the writ petition. In the writ petition, only the recognition letter without the conditions has been annexed. At page 53, you will find 53, 54. This condition is not there. And this appears to be correct. From the letter at page 552 of the state government, which does not insist on compliance of ROPA.
No, no, দেখতে হবে।
Kindly compare this 574, this condition, this page, that is left out in the writ petition. And page 552, I showed to your lordship that the government even in 2009 does not insist on compliance of ROPA. It says that talk with your employees and come to a solution, give some higher pay to their satisfaction. Even in 2009, the government is saying.
Yes.
The 2023. 2023. This is 2023, volume 4. Supreme Court cases 498. St. Mary's Education Society. Kindly take paragraph 36 first. Paragraph 36 at page 521. Page 521, bottom, paragraph 36. It needs no elaboration to state that a school affiliated to CBSE, which is unaided, is not a state within Article 12 of the Constitution of India. Referring to Satimbala, that is 2011 judgment. Nevertheless, the school discharges a public duty of imparting education, which is a fundamental right of the citizen. The school affiliated to CBSE is therefore an authority amenable to the writ jurisdiction under Article 226 of the Constitution of India. However, a judicial review of the action challenged by a party can be had by resort to the writ jurisdiction only if there is a public law element and not to enforce a contract of personal service. A contract of personal service includes all matters relating to the service of the employee, confirmation, suspension, transfer, termination, etc. Then, my lord, kindly come to paragraph 75, where the judgment, my lord, has been summarized. Paragraph 75, my lord, towards the end of the judgment. paragraph 75 at page 537. Page 537, paragraph 75. We may sum up our final conclusions as under. An application under Article 226 of the Constitution is maintainable against a person or a body discharging public duties or public functions. The public duty cast may be either statutory or otherwise, and where it is otherwise, the body or the person must be shown to owe that duty or obligation to the public involving a public law element. Similarly, for ascertaining the discharge of public function, it must be established that the body or the person was seeking to achieve the same for the collective benefit of the public or a section of it, and the authority to do so must be accepted by the public. Even if it be assumed that an education institution is imparting public duty, the act complained of must have a direct nexus with the discharge of public duty. It is indisputably a public law action which confers the right upon the aggrieved to invoke the extraordinary writ jurisdiction under Article 226 for a prerogative writ. Individual wrongs or breach of mutual contracts without having any public element as its integral part cannot be rectified through a writ petition under Article 226. Wherever courts have intervened in their exercise of jurisdiction under Article 226, either the service conditions were regulated by the statutory provisions or the employer had the status of state within the expansive definition under Article 12, or it was found that the action complained of has public law element. 75.3. It must be consequently held that while a body may be discharging a public function or performing a public duty, and thus its actions becoming amenable to judicial review by a constitutional court, its employees would not have the right to invoke the powers of the High Court conferred by Article 226 in respect of matter relating to service, where they are not governed or controlled by the statutory provisions. And educational institutions may perform myriad functions touching various facets of public life and in the societal sphere, while such of those functions as would fall within the domain of a public function or public duty be undisputably open to challenge and scrutiny under Article 226 of the Constitution. The actions or decisions taken solely within the confines of an ordinary contract of service, having no statutory force or backing, cannot be recognized as being amenable to challenge under Article 226 of the Constitution. In the absence of the service conditions being controlled or governed by statutory provisions, the matter would remain in the realm of an ordinary contract of service. Even if it is perceived that imparting education by a private unaided school is a public duty within the expanded expression of the term, an employee of a non-teaching staff engaged by the school for the purpose of its administration or internal management is only an agency created by it. It is immaterial whether A or B is employed by school or discharge that duty. In any case, the terms of employment of contract between a school and non-teaching staff cannot and should not be constituted to be an inseparable part of the obligation to impart education. This is particularly in respect to the disciplinary proceedings that may be initiated against a particular employee. It is only where the removal of an employee of non-teaching staff is regulated by some statutory provisions, its violation by the employer is in contravention of law may be interfered with by the court, but such interference will be on the ground of breach of law and not on the basis of interference in discharge of public duty. From the pleadings in the original writ petition, it is apparent that no element of any public law is agitated or otherwise made out. In other words, the action challenged has no public element, and writ of mandamus cannot be issued, as the action was essentially of a private character. In view of this, the High Court was justified in taking the view that the original writ application filed by the respondent 1 under 226 is not maintained. That is paragraph 77. টোটাল 5 পিটিশন আসছে আমাদের 3 জন খালি আপলোড
Here no government aid is received. No government aid is received.
No.
And government has also no control over the management.
No. And the management, so far as scale of pay is concerned, that is not in the management rule either. There is one government rule, that is rules for management of recognized education institutions, 1969. That rule does not deal with scale of pay. And in any event, this managing committee formation, etc., that is not governed by that.
So you are questioning the forum to decide, not the remedy as such. The forum to decide and not the remedy.
That's mainly. But kindly take this.
One is what you are arguing is this, that by reason of.
I have followed. The only thing is, so far as the merit of the matter is concerned, apart from the forum, page 5.
If you have given an undertaking, you are bound by the undertaking.
No, page
Now,
570.
Maybe
Kindly see
report
page.
report may not be the appropriate forum.
That is one aspect.
But they are not remediless. If you have
Maybe.
given an undertaking, you are bound by the undertaking.
Except
The individual teachers.
except
or
for
whoever
the
is
fact, my lord, that kindly take page 574 seriously.
there. Yes.
Page 574 in the conditions of affiliation. The particular clause 7 is struck out by the boards, and it is a document given by the board in its affidavit. That
Here the
condition
board
is struck
whoever
out.
is there in
And
the-
my lord, the correctness of that document will be further fortified by the fact that in page 552 letter of 2009 of the coming from the state, it says, my lord, that you enter into negotiation with your employees regarding the salary. Page 552, the last part, the last paragraph. It does not refer, my lord, to any ROPA.
No, what is struck off is that they may not be admissible benefits according to the granting aid rules. But what they are on is this. Suppose granting aid rules is not there. What about that? To the extent, if it is diluted, it says that no financial help from the state government will be required at any time. And that the scales of pay of the staff of the school will be the same, not less than as have been introduced by the state government for non-government schools. So your recognition is based on this.
But kindly read with it, page 552.
Yes, it says granting aid rules will not be.
No, page
applicable.
552.
We'll come to that. Granting aid rules is when the grant is given. So if I'm not giving you the grant, granting aid rules, if it is over and above what is payable under ROPA, that may not be payable.
Nothing is payable over and above ROPA. Why they granting it?
No, we are saying that for the time being, for the sake of argument.
Mhm.
that
I
if
followed
if the granting
the
aid
two aspects,
rules-
sir.
Yes, if the granting aid rules is severable from other benefits to which the teachers were enjoying, by reason of their subsequent qualification, that portion may be excluded. But that does not in any way dilute the condition of recognition given to you on the basis of you made a recruitment. It's a clear case of estoppel. If you make a representation induce other to fall in prey and they change their stances, then you are bound to obey this. You cannot come and turn around unless you are able to establish for some reason that you are not in a position to enforce it. Suppose you are in liquidation.
Now, my
But
lord, now, my lord, question is who is this you?
But we are not for the present. So first thing is that you are saying that REIT is not the remedy because service conditions. So suppose even if we hold that REIT is not the remedy, but they have a remedy.
The Supreme Court, my lord, I have referred to two judgments, 11 and 23, 2011, 2023. Nowhere the Supreme Court kept it open to be decided by a civil court.
That's why I'm saying that they cannot be remediless.
No, Supreme Court did not grant them liberty to move a civil court.
No, but that
2011 or 2023, none of them.
See, for every wrong there has to be a remedy. The Supreme Court
Provided
said-
there is a wrong.
Yes. So if you are inviting us to decide on the wrong, we'll decide. We have no problem.
But then, my lord,
But the
possibly
question
that
is
will
this-
not.
Question is this: if you say that we initially lack the jurisdiction to decide because there is no public law element involved in it, then the matter rests there. But that does not mean that they will not be allowed to have their remedy open. And to that extent, they may be entitled to Section 14 of the Limitation Act.
True. My lord, I am not, my lord,
Yes. So
joining there,
yes. So
joining issue there. The only thing is, kindly, my lord, keep in mind the fact that NTPC is not their employer. That is the judgment of this honorable court.
NTPC is not the employee in a given facts. That see, you cannot read a judgment like Euclid's theorem.
No, the
A
judgment
has to be read in the context in which it is decided. It does not decide on whether ROPA will be applicable or not applicable.
that is not on that.
That is why the
Applicable.
state government has said.
Supposing, my lord, it is
No, that is why the state government has said that you arrive at an amicable settlement. That is why the state government has said, possibly that is keeping in mind. Because you have shown them the path after they have almost, because where they will go at the end of the day. Because you have shown them the garden path after they travel some stage, they cannot be just thrown to the ocean and ask them to swim. So that's the reason the state government said that you got the recognition on the basis of this. We understand that maybe that for A, B, C reason, but you enter into an amicable settlement with them, which maybe even if they file a suit and they establish their right, it will sound in compensatory reliefs. That will amount in compensatory reliefs.
Yes.
So that is precisely what the state government and
My lord, pursuant to court orders.
Hearing them, they also want that compensation. That's all.
Pursuant to orders passed by the honorable division bench, coordinate bench in this matter, in this very matter. My lord, we have already made payment of a few crores of rupees to them.
No, that is for them to decide whether they are agreeable to that compensation or not. That's for them. So, Mr. Banerjee, at the end of the day, suppose we hold that the writ petition is not maintainable, then the question would arise, you will not be remediless. But at the same time, you will be entitled to some compensatory reliefs. So that compensatory reliefs, you have to take a call on that. Because today it is also a reality of the situation that there is no student. The close is allowed to be closed. The school is allowed to be closed down.
No, school is there anyway. Let me finish.
So-
School is there.
So no, we find from the order that the division bench said the school shall.
That is the
closed.
close.
In any event,
Anyway,
you cannot have teachers where there is no students. So there
my
is
lord,
also another.
I'm sorry to interrupt, my lord. These are all subsequent events and these are all has got nothing to do with my relief. Anyway, he has finished, my lord. So naturally,
It's not finished.
oh, I
So
see.
we ask you that whether you will be agreeable to have a compensatory reliefs or not, based on, of course, a settlement. That
A
is
very
what-
nice approach, Manoj. There's no doubt about it. At one point of time, the bench preserved Justice Dipankar Dutta attempt was made. And the money which is given to us is nothing. They say we cannot pay more than that. NTPC can pay. I'll place all these things, my lord. I'll place.
No, that is, see, that is not, It's a purely legal issue. All those facts are not relevant at all. It's a pure legal issue. First is whether the REIT is maintainable.
That is honest. First, I have to cross this hurdle.
First is whether REIT is maintainable.
Yes,
Second is if the REIT is maintainable, then to what relief you are entitled to.
that's true.
So whatever orders other benches have passed is only an interlocutory.
That's true, my lord. That's what I'm saying, my lord.
So that's why we asked you at the threshold
Yes.
that if there is a possibility of any compensatory settlement being possible in this case or not. That is
Very well, my lord. I'll have to discuss with my junior friends and the clients. There's a doubt about it. But one thing is very clear, my lord. Of course, I'll not run away from the field. Of course, I'll answer all these points raised by Mr. Gupta. I'll just put one question to Mr. Gupta. What prevented you to argue all this point before the court at the first instance?
No, it's a court of appeal.
No, can you appreciate? No. There is a Supreme Court judgment to that effect. But I had a privilege to arguing with Mr. Gupta in one case before the division bench. I want to raise some point. Decided on judgment. However, it shows the point which was not taken at the first instance, you are not permitted to go any further. But I'll answer. I'm not standing in the way.
They have not said that the REIT is not maintainable.
First point.
They have argued that the REIT is not maintainable.
Yeah.
Before Justice Gangopadhyay, they have not raised this issue.
No. And I'll try to find out from their own affidavit whether the particular plea was taken or not. Why I'm saying I'll cite all these judgments in the court. Today for the first time, I'm not like an assure, I'll not run away. But how is it? Today, what is the point? Court of the first is res judicata.
Mr. Gupta, you have not raised this point about the maintainability of the REIT.
I take what Mr. Banerjee says. I don't dispute that, but it's a question of jurisdiction.
No. Question of jurisdiction in, see, nowhere in Constitution of India it says.
Question of jurisdiction.
No, question of subject to correction. Nowhere in Constitution of India says that REIT cannot be issued against a private body. Nowhere in the Constitution says. It doesn't say. But the court has evolved through judgment saying that if a private body discharge a public function, but Constitution is silent on this. You have an option to file a REIT, you have an option to file a suit. Both options are open to you. But the REIT courts are not exercising their discretion because they feel that to be more an efficacious remedy. Nothing more than that.
I cite on Supreme Court judgment number 3, same point which are raised by your lordships. I cite the judgment, the power of the High Court on Article 206. It's much more wider.
And that if you have not raised this.
I am grateful to my learned junior. He points out that in our affidavit in opposition, the point was taken.
Point was taken. Very well.
And one thing, my lord. Point is that more dangerous. One thing, the point is taken. But I didn't argue, that means I waived. That's why I asked them.
Of course, you do not find from the reflection from the judgment that this point was.
No, of course, I understand that Mr. Sen was there.
So you
it was not even kept open.
Just a minute.
I'm sorry, my lord.
So you have not argued this point, which you are taking for the first time in the appeal. You have not argued. So the jurisdiction is not that the court has no jurisdiction. Court has a jurisdiction. Whether the court will exercise in REIT or suit, that's the discretion of the court.
Yes.
And if you have not argued that point before the trial court, then it has to be assumed for all purposes that you concede to the jurisdiction because it's not a lack of jurisdiction. The court has jurisdiction over the subject matter, dispute everything. But it's a question of because of discretion, the court will not exercise. That's a different issue. Discretion doesn't mean that the court has a jurisdiction.
That's true. And
discretion is
I will say it is something more than discretion also.
No.
Because this is a law settled by now.
It's a question of jurisdiction. Jurisdiction is not, it's not a nullity. Because the Constitution is supreme. If the Constitution doesn't say that you cannot have a writ of mandamus against a private body, then we have no jurisdiction to say that it cannot. But the courts have said that since it's a self-imposed
restrictions,
nothing more than that, and these self-imposed restrictions have been widened, expanded whenever it is required. Otherwise, the appeal would not have developed.
May I react to this?
No, sorry to interrupt, my lord, just a minute. I couldn't understand.
And then you also have to address us that this point was not raised before that.
No, it was taken in the affidavit, as they say.
I take it that the point is not raised.
No, you have taken. There's a difference, my dear friend.
Not
Please
raised.
take yours. Please take yours.
But the question is, it is not a self-imposed restriction like the cases of delay.
But it's not a lack of jurisdiction
This
either.
is- I will submit this is a lack of jurisdiction because Supreme Court has explained what the Constitution means, what the Constitution says. When the Constitution says in Article 226 that it will issue to authority person, etc., it doesn't mean, my lord, there are judgments that person here does not indicate a person, my lord, not in office, not holding, not discharging public duty. Person in Article 226,
26 says subject to correction. It covers public fundamental rights and any other legal right.
against whom?
Legal right.
Any other legal rights against whom?
And a constitution.
To issue to any person or authority, including in appropriate cases any government. This person in 226 has been explained by the Supreme Court not to mean a private person, not having public.
So we come to this.
Therefore, this is a constitutional bar which the Supreme Court has.
No, 226 does not say shall have power throughout the territories in relation to exercise to issue to any person or authority, including in appropriate cases in
Government.
including in appropriate cases. So government has been separately defined. Within whose territories relations are in such, including retain the nature such and such. So Supreme Court has explained this by saying that it has to be a the authority, a private authority discharging public function is amenable.
Exactly. That is, my lord, explaining Article 226. It is not, my lord, that the court is in its discretion.
It's not, as I said, it's not a lack of jurisdiction going by the tutor. It says that we are, because there are category of judgments, Mr. Gupta, you are aware of this, that where Supreme Court says a self-imposed restriction.
My lord, regarding delay, Supreme Court has said that.
No,
But
you
not
don't-
regarding the maintenance of the petition on the ground.
The Supreme Court has said that we are, because we are contractual matters, for example. Supreme Court said there is a self-imposed restriction. So this is a matter which the Supreme Court feels that such disputed questions of fact cannot be conveniently
That's a
decided. in the
different
way-
aspect.
No, it's in Article 14. And Supreme Court said that even these facts and circumstances, we are not inclined to exercise our jurisdiction because it is not convenient for us. So all the decisions where the Supreme Court has not exercised their jurisdiction either, it's a complicated questions of trial is required, although in Rajnaran's case, we have seen in 226, the evidence was taken by the court. So in appropriate cases, it's possible. It's not that it is not possible.
My lord, it is possible to go into the facts.
Yes.
No dispute.
Yes.
It
So
is possible.
You are saying today, you are saying that this NTPC is amenable to Article 12, no problem about it. But the sphere in which it was working, in that sphere, when you are enforcing the right, it is not amenable under 226 for that matter. For example, CSC.
Exactly. Just like that.
For example,
Just like that.
CSC.
But the question is, my lord, does
Now, this issue, you may have taken a point in your affidavit, but you have not argued before.
supposing I have not taken the point in the
So will it be a
affidavit
lack
either.
of, it will be a lack of jurisdiction?
My lord, I
Or do you
beg to
concede to the
submit.
jurisdiction of being tried because it will not be a nullity as such, because if you don't have a jurisdiction, it becomes a nullity. But it doesn't go to the extent of saying that it's a nullity. You may have waived
My
your
lord, the
right.
Supreme
to
Court has
argue on
nowhere
this point.
said, nowhere used that expression nullity, but it has decided on this aspect to include, my lord, to say, my lord, that the 226 will not issue against any private person for any private work. That part is, my lord, well settled. Therefore, that touches the question of jurisdiction.
Very well.
Unless there is a public law element in it, my lord, the 226 court will not exercise its jurisdiction. It cannot. That is, my lord, the well settled principle of law set down by the Supreme Court. Now, my lord, there is no deviation from this.
Then what would happen to
This
those
is not a
line
case of,
then what would happen to those line of cases? I think that 83 and 84 Supreme Court, I think Lotus is one of them, which says that if this point we have not taken it at the threshold, and after the hearing is concluded, you cannot take the point that the court has a jurisdiction.
But so
What
far
would
as
happen to that?
jurisdiction aspect is
What would
concerned, my
happen
lord,
to that, those line of cases?
my lord, kindly, my lord, bear in mind, my lord, the aspect of jurisdiction stands alone from all other aspects, all other points, my lord, whether taken or not.
So as those judgments where Supreme Court has said that if you have not raised and taken this plea, then the jurisdiction point is not allowed to be argued at the
My lord, plain and simple, the question of jurisdiction.
So I think 83 or 84 Supreme Court is there.
My lord, I go back to 54.
Yes.
I go back to 1954 Supreme Court, where Supreme Court in Kiran Singh versus Chaman Paswan had stated that the question of jurisdiction, not territorial or financial, not pecuniary, but the jurisdiction regarding subject matter. That is, my lord, that jurisdiction issue, that jurisdiction issue can be taken at any stage of the proceeding, and even for the first time in the execution proceeding also.
No, but that is in relation to Code of Civil Procedure.
True.
And where is following Sir Ashutosh Mukhopadhyay's judgment, followed in subsequently in Sachidananda's case, official trustee. So that is a different issue altogether. When you are deciding on 226,
that's the
226 CPC is subservient to Constitution.
Absolutely,
Constitution is
but then
supreme.
here the bar is of Constitution itself.
The cases I am sharing with you are the cases where the Supreme Court in deciding 226 has said that if this point you have not taken, you will not be allowed to take subsequent.
My lord, with on the aspect of the jurisdiction of the
Absolutely
on the
jurisdiction.
no, I'm just let me kindly let me to complete the sentence. The Supreme Court, my lord, I have not found any judgment of the Supreme Court has said that if you have not raised the question of non-maintainability in view of the absence of public law element, it cannot be raised in the appellate stage, because this is purely a point of law emanating from the interpretation of the Constitution itself. And so far as the interpretation, so far as the questions of points of law are concerned, my lord, the courts, my lord, your lordship's court allow it at every stage, and even for the first time in the SLP also.
Yes.
In regard to points of law. This is, my lord, the high pedestal on which a point of law is held. And I humbly submit, my lord, that this point regarding the enforceability of a contractual term, this is a purely contractual term, is not emanating from any public law duty or public law element. This is not enforceable through a writ proceeding. On this, my lord, the Supreme Court is very certain, I mean, a host of judgments on this point. That is, I have cited two judgments, my lord, that unless there is a public law element involved in it, the court will entertain a writ petition. Now, my lord, the fact that whether I have raised it before or not, my lord, that will not confer a jurisdiction on the court. Because Supreme Court, my lord, says that a private remedy cannot be enforceable in a writ petition, whether the point is taken or not, and court has decided either way, the first court, it doesn't matter, because if it comes to the notice of the court, even at the appeal stage, the court will certainly will not entertain this point, that to find out whether the trial court had committed an error or not, whether there is some error in the order of the trial court regarding the maintainability of the writ petition. The point is not taken before the trial court passed a judgment in a particular way, but the point is raised here before us. Therefore, we are, as a division bench, your lordships will most certainly have the jurisdiction to go into this aspect, look into this aspect, and decide for yourselves. I'll continue on the next day.
Yes, continue, no problem.
Because your lordships were asking me to cite some further more judgments. That is why I said this. Now, my lord, I assume.
No, please consider those judgments. I think 83 or 84 Supreme Court.
আজকে এই হলো কাজের হবে না তো আজ আর হচ্ছে না তাহলে বল তুই কয়েকদিন নিমিত নেই
Eighty-four possibly lordships are referred to Radhakrishna Agarwal. 84.
83 or 84 Supreme Court. And there is also a judgment by Justice Indira Banerjee, I think in Supreme Court also.
75.
No, by Justice Indira Banerjee in Supreme Court,
Oh,
I think there is some judgment by his, her lordship.
পরের দিন নিয়ে আসবি দেখাবি হবে মামলাটা চলছে বিদ্যুতের ওইখানে We'll find it out, my lord. For our interest, we'll find it out. Certainly. But there is a basic difference, my lord. The argument which is advanced by Mr. Gupta.
You conclude your substance. Yes. You want to cite some judgments? You said what judgments you want to cite?
My lord, the other judgment that I want to cite is regarding, my lord, assuming that anything is payable, whether law of limitation gets attracted or not. For what period I'll have the liability
If this,
to make the payment,
if this proceeding to be held. to be
because
followed-
it is not a statutory liability. The contractual liability.
It's a, yes, contractual liability.
For how long?
So they file a writ.
Okay.
They file a writ. The moment the writ is held to be, discretion is not exercised, they cannot be held remedialess. So they will be entitled to the benefit of Article 14(2).
No, that is about the suit.
Yes.
I am on the point that supposing in a suit, your lordships are hearing the suit. What I mean, relief up to which period, for how many years can be given regarding the higher salary? Because this is a contractual liability, not a statutory one. Therefore, the law of limitation will apply.
So long their employment continues, your liability is continuing. Because when they file it, suppose when they file it, then ROPA 98 was there. Just for sake of argument. During the pendency of the proceeding, ROPA 2009 had come. So if the proceedings did not terminate.
My lord, if your lordships accept my submission that writ is not maintainable, and my lord, because we have no obligation to make payment as per ROPA. That's the Supreme Court view. We have no obligation to make payment as per ROPA. Forget about the contractual or public law or anything else. ROPA is not applicable to this set of employees. That's the
Government doesn't say so. Government on the basis of.
not the government.
See, you are a private body. Suppose let us take a private body. If you say, we have decided a similar matter in which your junior Mr. Mujumdar was appearing, and he won the matter, of course, that was by an act.
That was by?
By an act. Where the employees who were in the private sector, they were taken over by the government with the same kind of de-getting facilities as that of the central government. And we decided that
yes,
that they are entitled to that.
Exactly. That is so.
Yeah, so that
But-
was, there was no
but-
obligation, no, there is no obligation, but it's a question of.
But that was a statutorily
No, no.
cast obligation.
Suppose there is no statutory flavor. You have given you got a recognition, you could not have got the recognition but for this giving this. So if you have given if you, for the purpose of obtaining recognition, you induced everyone surrounding you, including the board, to act in a particular manner, otherwise you would not have got the recognition. And on the basis of that recognition, you recruited staff, giving them with a promise that you will be receiving a payment because they may have a scope for alternative employment. And that in future, so long you continue, you would go on receiving the benefits of a government teacher or government whatever is said, and with all the facilities. Then that is a contract between, say, forget about this, a contract between the teachers whom you are recruiting and yourself. Forget about whether it's a statutory force or not. This is always enforceable.
There, my lord, I am raising this issue. Enforceability of a contract, so far as monetary claim is concerned, that is restricted to 3 years in respect of a contractual obligation. That is restricted to, I mean, my lord, that part of the wrong, even if it is taken to be wrong, they have their right, but they don't have the remedy. The remedy is limited to 3 years. The right remains. The remedy is limited to 3 years. That is, my lord, the law of limitation. And that will apply, my lord, where your lordships find that we have the obligation. Now, my lord, the Supreme Court judgments that I have I have placed before your lordships, those judgments say that we don't have the obligation to pay at such rate. Forget about undertaking or anything. Court says we don't have the obligation. Court merely does not say that REIT is not maintainable. Court goes one step further. Court says that this obligation is not enforceable.
It was said in the context of equal pay for equal work. In these cases, you will not find that this kind of undertaking was there. It was on a question of equal pay for equal work.
No.
Yes.
Kindly see, my lord, this 2011.
Yes.
Kindly see 2011 judgment. 2011 judgment. 2011 judgment. Paragraph 16 first, my lord, I had placed. In our considered, your lordships on this judgment, paragraph 16. In our considered opinion, the division bench of the High Court has rightly held in the impugned judgment that the teachers of private unaided minority schools have no right to claim salary equal to that of them.
Yes, equal to that of their counterparts working in government schools and government aided schools.
Therefore, my lord,
so they say they came for possibly that I am doing the same work which my counterpart is doing in government. So you give me that. So court interpreted Article 30 and 226 and said that yes, you are not entitled to this.
Court, my lord, does not merely say that the writ petition is not maintainable. The court also holds against their very entitlement. It's not merely the question of maintainability of writ petition. The question is that they had no right to claim salary equal to that of. Court is deciding their right also, not only, my lord, the forum, but also the right.
You read paragraph 23.
Paragraph
23.
Kindly before that, paragraph 22.
Yes, please read paragraph
22. In other words, the state by making a statutory provision in section 12 of the Delhi School Education Act, which was discriminatory, had violated the mandate to the state under Article 14 of the Constitution not to deny the equal protection of the laws within its territories. This decision in Frank Anthony does not assist the appellants in any manner because the guarantee of equality, as we have said, is not available against an unaided private minority school. Therefore, court may not going by Article 14. Is not going by Article 14, not going by equal pay for equal work. It simply says that you are not eligible, you are not entitled to get it.
You forget about it so far as the undertaking is concerned that binds you with the teachers.
That is purely contractual. Here also the same.
No, but you cannot say that it's not enforceable. Enforceable or not in a proper proceeding.
I am not an enforceability. I am on the question of the existence of the right to enforce.
Yes.
Not enforceability. Enforceability is right exists whether I can enforce here or there.
They have a right.
They do not have the right. Will kindly read paragraph 16 once more. In our considered opinion, division when the High Court has rightly held in judgment that the teachers of private unaided minority schools had no right to claim salary equal to that of their counterparts. The existence of the right is negative. They don't have the right not to speak of enforceability. And if your lordship kindly takes page 20 paragraph.
So according to you, what the rights have these teachers?
Apparently, the rights the teachers have.
What right they have?
Milord,
how their salary to be fixed?
Milord, their salary is to be fixed.
Have you ever fixed the salary based on ROPA 1998?
Yes.
Just a minute. Have you fixed it in terms of ROPA 1998 or not? Because you say that this undertaking is not binding on you. Then you should have fixed the salary disregarding ROPA 1998.
We have fixed the salary once under ROPA 90 or 98, whatever, possibly ROPA 90, and we continued with that.
So if you have acted upon a particular thing, then can you turn around and say that it is not applicable to you? You had the option not to accept and to turn around and say that
if something is not applicable to me and I apply it, does it create an estoppel against me? This will be an estoppel against law.
It's not an estoppel against the statute. It's a estoppel per se between two individuals. It's not an estoppel. If it's estoppel against statute, yes.
In contractual field.
It's a contractual estoppel.
Exactly.
If it's a contractual estoppel, you cannot resile from it.
Each ROPA gives a separate cause of action.
See, ROPA 98, when it was implemented, you were paid. It is an admitted position that when they complain, when you stop.
Exactly.
When you stop, tell us when you stop.
They have in 2014 which fed 98 at 2009.
They were not even given 98 ROPA. Up to 90, only 90 possibly, yes. Only 90 ROPA. After that, no, they filed the writ petition in 2014, asking for 98. 98, 2009, both.
Why do you in your affidavit have said how long you have paid your salary to them in terms of ROPA, available ROPA? When your affidavit you have said so? Show us.
The school managing committee. School managing committee.
Show your affidavit. What you have said on this?
What we have said in our affidavit is that the payment of salary or the terms and conditions of service maintained in respect of the school everything was done by the school managing committee and not by NTPC at all. That is
Mr. Gupta, we ask you a very simple question. Whether it is a managing committee is only an arm.
No.
Is only an arm.
No, and there was a specific contract with this that in the event of any shortfall.
No, we want to know you for a very simple thing. How long these teachers, they received benefits under ROPA 90 or 98 or 24, whatever is there. How long? Please tell us. Please tell us. And where you have said so in your affidavit. Because you cannot make a completely different case in appeal. First of all, you have not argued the question of article, the writ is not maintainable. Secondly, You are not in a position to say how long they were paid these benefits. Someone must say where your affidavit you have said. Show us. You are arguing a question of limitation. Let us see what you have said.
This is part of the argument. Basically, an argument into how to guide it. Just one. Just but the part of part of submission negotiation.
If you want to go through it, you can come back. We have no problem. But please go through it and then answer, or otherwise we don't want you to commit any mistake on this.
My lord, the learned single judge in his judgment, my lord, if your lordship kindly take at 465.
Just plus first row from your affidavit. What you have said in the affidavit? Show us from your affidavit.
I'll show that, but here what I was going to show is that the court, the learned single judge has himself held that ROPA is not applicable to him. Learned single judge has held. Lord, I shall refer to my affidavit in opposition.
122
Page 122. It starts from page 122.
Of your affidavit.
Lordship.
122.
122. I am not starting. I am not beginning from the first page. इसे तो बोल रहा हूँ क्योंकि अच्छा चीज किसको अच्छा नो ए कॉन्सेप्ट এটা বলেন it was paid, my lord, up to which year? That has not been stated in the affidavit, because in paragraph 13 we have said, my lord, that the appointment letters were issued by the principal and member secretary of NTPC High School, and NTPC was in no way concerned with the same. One employee of NTPC was the principal and member secretary of the school concerned, and everything was done by him. I mean, by the committee.
School was formed by whom?
School was formed by me. Yes, absolutely, because the assets, entire asset belongs to me.
So DAV's public school is your school?
No.
It is a society which was managing.
My lord, from the beginning, a society.
Asset of DAV public school belongs to whom?
Asset of DAV public school belongs to NTPC. The asset only, but not the school. So far as the school is concerned, the school was not, my lord, set up by the NTPC. Management was never by NTPC.
Who has constructed the school building?
You know, as I said, you know, all the landed properties, building, etc., everything is owned by NTPC.
Out of your own fund, the building was constructed?
Exactly, land and building.
So
land building, but not the management.
So NTPC school was the school that you were running. This school was from this DAV building, or it was handed over to
from NTPC building. But
so
later on it became NTPC.
So same structure which was NTPC school has renamed to DAV school.
Yes.
It was renamed?
Not renamed. NTPC school DAV.
Yes, NTPC
it was like
school,
that.
Yes. So DAV is having a prefix or suffix of NTPC.
No.
And this
DAV
have a member in the school managing committee?
Yes.
What is the source of fund of the school?
the tuition fee. Tuition fee shortfall up to 1 lakh per month or 1 lakh per year is to be paid by
No,
NTPC.
no, the salary of the teachers and others who are paid.
Paid by the managing committee from the tuition fees.
From the
Tuition fees. It was being run by DAV. DAV, my lord,
DAV school, how the corpus of the school was built. A school cannot, because from day one, they will not get tuition fee.
not from day one. As I said, my lord, we ran for
What you
few
have shown
years.
in your balance sheet about DAV school, your balance sheet will speak for itself.
Not my balance sheet will not show
Of course, because your asset, in the asset, in the NTPC asset,
only the
it has
value
to
of
be
the,
shown.
it will show only the value of the asset.
The auditors must have said, you have, please check your balance sheet. How this shown in your balance sheet?
It cannot be shown. It can be shown only as an asset, as a property.
So you own
Yes.
the asset. You own the
I-
asset.
Of course, yes.
The asset is your DAV school.
The asset is the land and the building on which the school is being
And
run.
you also provide, because you are, see, it is not on a license basis or not a
I
fee.
am providing the shortfall only up to a ceiling.
Are the DAV school paying any rent, license fee, anything?
No, nothing.
No,
Nothing.
nothing. So for all practical purposes, it is you. That is why I said it is your extended arm.
My lord,
Otherwise, you have no obligation to pay 1 lakh or 2 lakh, 3 lakhs. If you are showing a complete severance between yourself and DAV, that there was no necessity of you having anyone in the managing committee of the school or for supplying them some fund
managing committee
to meet their shortfall.
managing committee
Alter ego, objection করে থাকতো।
So you have, it's a alter ego, absolutely an
alter
alter ego. It's only an alter ego.
My lord, if your lordship hold that is an alter ego, there is a judgment already subsisting, which was appealed from, but then my lord not proceeded with. My lord, therefore, my lord, it remains on record that NTPC is not running the school, or NTPC is not the employer in respect of this stuff.
There's a distinction. I may not be an employer because managing committee has given the letter of appointment. But the school, for the purpose of providing any facility, is by NTPC. Maybe in your record, of course, there is a judgment. We need to.
Not only judgment, my lord, DAV is already on record as the authority which is running the school.
No, there is a finding by the trial court.
Well, whatever the finding is, I can show to your lordship that DAV had been running the school.
2001.
Huh?
November 2001.
Since 2001, DAV had been running the school. I have records to show that.
DAV was running on the basis of the show that they are not, because previously must be so, Mr. Gupta, you check up, must be in your books. Before the DAV was there, they were shown as your employees. Now, when the DAV has come, these employees were shown, taken out from your books and created in DAV. DAV must have a separate accounts. It must have been audited. It must have filed returns with the DI school.
DAV,
Yeah, DAV.
the existence.
So DAV, and this is being funded because you see, DAV cannot have any, that is why it said that DAV cannot have any independent existence.
May I beg to know one thing? Why we are going into this aspect?
No, because you said that that NTPC has nothing to do with the DAV schools. That's why. How a recognition is.
Supposing NTPC has got to do has got everything to do.
That is no. You want us
Forget about DAV for the time.
Want us to decide that they have no enforceable right. That is why it's so many questions.
The enforceability.
That is why we ask you so many questions. Otherwise,
even if we proceed on the basis,
if we decide that the reach is not maintainable, it is not necessary for us to decide whether they have an enforceable right or not. Their enforceable right will be decided in the appropriate forum. But If you want us to decide whether they have an enforceable right, then you are inviting us to also decide. Also decide the jurisdiction.
one thing. In the judgment in 2011, the Supreme Court has specifically said,
Yes, we have heard it 100 times, Mr.
yes,
Bisnoy.
and therefore, my lord,
We were aware of this.
do they have any right?
Very well. We have argued.
Now forget about DAV. Supposing DAV was not involved at any point of time, NTPC has been running it. Then it is squarely a situation which the Supreme Court has considered. There, the Supreme Court specifically says in paragraph 16 of this judgment that the employees do not have any right to claim parity with the pay scale of the state government. Therefore, the very existence of the right, Supreme Court says, does not exist. Therefore, it's not merely on the forum that the judgment is passed. The judgment also goes by this, the judgment also decides the right to claim equal pay. That is how, my lord, I read the judgment. It not only, my lord, says that it is not the proper forum, it also says you do not have it. Therefore, if your lordships, otherwise the Supreme Court would have left it open to be decided by the appropriate forum. That is not done. Why? Because paragraph 16 specifically says they do not have the right to claim. The claim is not made. If your lordships will decide this on the question of maintainability in my
No,
favor.
we will not decide piecemeal. You argue whole hog.
If I say, my lord, if your lordships decide on the question of maintainability in my favor, then the other question is whether in that situation your lordships will be giving them an opportunity to move the appropriate forum. Now, if that opportunity is given and your lordships hold that as may be available to them in law, that will, my lord, keep my stand open also. And my lord, I am quite agreeable to that.
No, we'll also hear you on merits, both. Please also address us on merits. We want to hear you on merits as well.
My lord, merits means, my lord, the merit has been decided by the Supreme Court. They are not eligible. My lord,
so that's your.
I just point out to your lordship the fact situation. There is a condition in the recognition letter that you have to pay as per government rate. There is no statutory rule. There is no general executive order.
Yes.
Whether in this situation, as was present in the case considered by the Supreme Court, and as is present in the case before your lordships, this situation is identical. And in that situation, the Supreme Court said that the employees do not have the right to claim wages as per government rates. Now, my lord, this is the merit. My lord, going into the further aspects, my lord, as your lordships were raising at a point of time, as to the the method of accounting, who is the owner of the property. My lord, these, even if everything is assumed against me, in the sense that the property belongs to me, the DAV is nothing but an alter ego. If everything goes against me, NTPC, let us proceed on this basis. That is, it's an NTPC run school all throughout. And NTPC is not keeping the promise that it had made while obtaining recognition. The first question is, are the employees entitled to file a writ petition and claim similar benefit? The Supreme Court in 2011 and 2023 says no. The writ court is not a proper forum because there is no public law element involved in it. The second aspect is, they may raise a claim that I have the right to obtain this. Your lordships may hold that whether you have this right or not, fight it out in an appropriate forum. This is not the forum. Your lordships may hold that. And in that situation, kindly also say that to any other forum as is appropriate in law. On merits, my lord, there is no further cases left. We need not go into all factual details. Because whether DAP or NTPC or local management committee, whoever runs this school, the only relevant fact here for your lordship's decision is, my lord, at the cost of repetition, I say, that recognition, that condition of recognition. Well, that's the only thing, my lord, lordships need to consider, my lord, in my humble submission. What is the effect of that? Fortunately, in the Supreme Court of judgment of 2011, that situation was there also. And in spite of that, the Supreme Court said that they are not entitled to claim equal wages in the identical situation. Secondly, the Supreme Court said that this is not maintainable because no public liability. In my humble submission, no further fact need be placed before the lordships on the aspect of the merit of the matter, merit of the claim.
That is up to you, Mr. Gupta.
No,
How far
that's
you will place? How far you will place this?
but I still, my lord, pray that your lordships may kindly allow me to come back on some other day, my lord. I need to consider it because this has gone, my lord, somewhere above the argument I was really prepared to make. Some because it's the point is coming from the court and serious question is involved.
Yes, please. But that's why I said that if you want to argue on another day, you are most welcome.
Because I need to sit with my learned junior, and Mr. Vikas Ranjan Bhattacharya he's leading me in that.
How Vikas can lead you?
Because, my lord, he got senior gown before I. Senior gown. He got senior gown before.
জুনিয়র আমার হচ্ছে ঠিক আছে বলছি 8-9 বছরের কম কম তুই জাজমেন্টতে
So next Monday, parted at the top, and you give your notes of argument in the meantime. You file your notes by Friday.
Oh, the copy to us, Maida, so that we can also answer.
Please give your notes by Friday. All of you, whoever wants to file, you give your notes by Friday.
For one day, my notes of
Friday. After that, we'll not accept anything. Friday, you file it. Otherwise, not.
I don't going with the land.
But not the notes.
The notes, unless I hear you, how can I prepare my notes? Based on their argument, I will prepare my notes.
Just দেখি একবার যেটা লক্ষ্মীরা
তোদেরটাকে দে
already you have given us. It's already ফেরত দিয়ে দাও।
এই জাজ সাহেব ডাকছেন দেখো না
আচ্ছা ফেরত দিয়ে দাও বুদ্ধ সাহেব। কারণ অলরেডি উনি দিয়েছেন আজকে।
ওটা আবার কি
earlier page, 11:13.
So our list of days may be recorded, there is in 5 minutes. I'll try my level best to convince your lordships, my lord. Whatever argument has been advanced by Mr. Gupta, probably at the cost of reputation, probably distinguishable. Probably distinguishable.
Otherwise, why lawyers on both sides exist? Always distinct.
ওখানে কি
Every
আর কি আছে দেখে দাও।
Filed by the DC, my lord, last occasion I thought.
No, affidavit is purely a very
That is in supplementary affidavit and your lordship's order also reflect that.
এটার সঙ্গে কথা।
কি কপি আমাদের দে?
Only there are 5 writ petitioners. Now everybody else is.
No, we are right from the beginning. We knock the door of the temple of justice
That's
first.
5. That's 5.
If
I
somebody
said
comes, how can I be?
5 is all right. One after other, everybody is coming.
I think they have filed an application for addition of party. Also.
Applicant party, additional party here as respondents.
If they are similarly placed, my lord, certainly they can file.
But those who have filed the application. for
They
addition
never felt aggrieved. They had been sitting on the fence. Now everybody is coming.
may not get the relief. Those who have come.
No, my lord, sorry to interrupt, my lord. Since this point is raised, of course, I am not their counsel. There is a true judgment of the Supreme Court. Even if it is not moved.
And there is a judgment of division bench went down to Supreme Court, said those who have filed only they will be given. Because they are sitting on the fence, watching what would happen.
That's true, my lord. But
That was Shivnath Kole and.
but I am not their counsel. I am not interested. I am really, I'll try to protect my
Those
interest.
who are vigilant, they will get the relief. Those who are not.
87 এই 4 সালে কি উঠে যাবেন তাহলে আমরা চলে যাবো
Yes, call the next part.